When is LD 920 going to be heard? Or which order?
I think it's, now you would ask me because I just closed that screen. I think it's 920 is second from the last.
If it's possible, Mr. Chair, I'd like to see if our clerk or analyst could post the order in the chat and also perhaps even in a comment under the YouTube stream.
Yep, and I'm going to announce it as when we go on first. So let me know when we're live, Jordan.
We are now live.
Okay. So welcome to the Joint Standing Committee on Energy, Utilities, and Technology. I am State Senator Mark Lawrence, the Senate Chair of the committee. I represent Southern York County, the towns of Kittery, Elliott, York, Ogunquit, South Berwick, and half of Berwick. With me today is my co-chair, Representative Barry, who I'm going to ask to introduce himself.
And good morning, I'm Representative Seth Berry, and I'm proud to represent House District 55, which is Bowdoin, Bowdenham, almost all of Richmond, and beautiful Swan Island on the Kennebec. And I just had my one and done J&J COVID shot yesterday.
Great, congratulations. So we are going to go around and introduce the committee members around the virtual horseshoe, but I did want to announce up front kind of the order we're going through today. Not kind of, but the order we're going through today. And it's just been done because we had a couple of, we have one cancellation just this morning, just yesterday that was approved, just this morning that was approved. So we're going to be starting with 1008, an act to require joint use entities to establish permanent liaison with all county emergency management agencies. Then we're going to go on to LD 1130, an act to establish a public registry for automated telephone calls and so-called robocalls. Well, that will be followed by LD 933, an act to facilitate the expansion of broadband and unserved areas in the state, to unserved areas in the state. Next, we'll do 1107, an act to create needed broadband infrastructure in rural Maine through the establishment of a satellite-based broadband grant program. We'll then go on to LD 920, an act to promote oversight of and competitive parity among video service providers. And we'll end the day with LD 815, an act to support school decarbonization. And we will be taking a break approximately about 10:30 to allow the committee members to step away from the Zoom, get a little bit more focus, and have a chance to relax for 15 minutes before we complete the remaining hearings. If I'm in the middle of a bill, we won't do it exactly at 10:30, but it's going to be approximately at that time. So that'll give people in who are attendees waiting for bills a chance to know kind of what their priority is. So I'm going to go around the virtual horseshoe and ask people to introduce themselves. I'll start off with Representative Kessler.
Good morning. My name is Chris Kessler, and I represent District 32, which is the middle portion of South Portland and a little smidgen of Cape Elizabeth.
And then I'll go to Representative Wadsworth.
Good morning, Nate Wadsworth, House District 70. I represent 5 towns: Hiram, Porter, Brownfield, Freiburg, and Lovell.
And Representative Wadsworth is the House Republican lead on our committee. Next, we'll go to Representative Ziegler.
Good morning. I'm Representative Paige Ziegler from District 96 in Waldo County, the 7 towns of Belmont, Liberty, Lincolnville, Montville, Morrow, Palermo, and Searsmont.
And next, we'll go to Representative Grochowski.
Good morning, all. Representative Nicole Grochowski, serving House District 132, the people in Ellsworth and Trenton.
Next, we'll go to Senator Vitelli.
Good morning. I'm Eloise Vitelli. I represent Senate District 23, which is all of Saginaw County and the town of Dresden and Lincoln County, and I reside in the beautiful little town of Arousing.
Next, we'll go to Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Next, we'll go to Senator Stewart.
Morning, everyone. I'm Trey Stewart, State Senator in District 2, 51 communities in Southern Aroostook and Northern Penobscot counties, including the lovely town of Easton. And they're actually raising money right now for a new park, which I should give a shout out for. It's a great project. Strongly encourage you look into it.
Yeah, I'm not going to encourage people to do shout outs for their favorite charities, but I'll let you get away with it, Senator. And Senator Stewart is also the Senate Republican lead, and he's looking very loyally in his glasses today. Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville.
And last but not least, we're going to go to Representative Foster.
Good morning. I'm Steve Foster, representative for District 104, which includes the towns of Dexter, Exeter, Garland, Stetson, and Charleston.
Okay, and with us today is our new clerk, Jordan. And Jordan is the person you contact if you have technical or scheduling issues or access issues. He's your first point of contact. And our analyst today is Dan Tartikoff. Dan is one of our two analysts. We share Deirdre Snyder and Dan as our two analysts. They're trying to even out more equitably the number of bills they share between them. Dan primarily was the analyst for environment and natural resources, and Deirdre was our analyst, but they're trying to get a 60-40 split between them on the number of bills they deal with. So Dan will be doing a number of the bills today. Okay, I'm going to go a little bit over the guidelines for public hearings, and I know many of you have heard this before in the public, but I just want to go over them since we are dealing with a new platform and kind of how to deal with everything. So the clerk has sent out adequate notice of the hearing and given the sponsors and the public notice about what's going to be going on. Notice of public hearings have also been posted on the legislature's website and includes the method by which members of the public may attend. We have a quorum present, which I have noted, and the purpose of these hearings is to invite the testimony from members of the public regarding proposed legislation that is pending before this committee. The committee will hear testimony from persons present, including those participating by phone or by Zoom, who wish to speak for, against, or neither for nor against the bills to be heard today. With leave of the chair, committee members may ask questions of the person testifying today. Other questions, meaning questions by non-committee members, are not permitted. Whether or not you are going to be testifying, you may submit written testimony to the committee. Please be mindful that testimony is public and is available to all once it is presented. Written testimony will be posted on the legislature's website for viewing by interested persons. Persons testifying at the public hearing today are advised that the hearing is being streamed over the internet and may be heard by persons listening online, and that the video stream is also being recorded and will be archived with the legislature's webpage. If you wish to testify when you come up, please state your name, your residence, and if you are representing an organization, please state the organization you are representing. Testimony will be heard in the following orders. We're going to hear from the sponsor and then any co-sponsors who wish to testify. We'll go to people speaking in favor of the bill, people speaking in opposition to the bill, and those speaking neither for nor against the bill. If you have written materials to accompany your testimony, please submit them online if you have not done so already. And just as an aside, we do have a 3-minute rule in this committee, which means people are allowed to testify for 3 minutes, and then I'll gently try to redirect you to end your testimony. So if you are submitting written testimony, there's no need to read your testimony or to summarize or to read through the whole thing if it's very long. What I would suggest you do is in your 3 minutes, point us to the highlights in your written testimony. People on this committee do read the written testimony very thoroughly before and even during the work sessions or in between work sessions on bills. So the more detail you can submit in your written testimony, the better. And the more you can be very brief in your verbal testimony, just to direct us to the high points of what you want us to pay attention to is very important. Members will often go back and review the video stream from the hearing before a work session just to refresh themselves on the bills. We do not allow people, I should say, who have testified once before. If you testified previously and somebody asks a question of a witness who comes late, or member of the public who comes later testifying on it and asks a question of them, if you've testified previously and know the answer, you're not going to be allowed back in to answer that question. Questions are merely directed at the person testifying. It's once and done, and then you will be moved to the attendees status. We do have a list of people testifying on each bill, and I do ask people in the public if you can testify. If you can sign up to testify by 10 p.m. the night before. That allows Jordan to prepare and finalize this list for us, so we know what's going on during each day. But it is sometimes difficult for us to add people in at the last minute. So I don't want to discourage you from trying to do that, but I do want to make it clear that signing yourself up ahead of time is the way we'd like to have you do. It helps us to organize these things on Zoom so much better. So we're going to start out with our first bill, which is, and we're going to go in the order I stated earlier in our hearing. We're going to start out with LD 1008, an act to require joint use entities to establish permanent liaison with all county emergency agencies. It's being submitted by the sponsor, Representative Tepler. Representative, how are you?
I'm well, thank you, Senator Lawrence. Good morning, Senator Lawrence and Representative Berry and the honorable members of the Energy, Utilities, and Technology Committee. My name is Denise Tepler. I represent House District number 54, which is all of the town of Topsom. And this is my first ever appearance before the Energy, Utilities, and Technology Committee. And I will ask your leave at 10 o'clock. I have a renomination hearing in my committee that I have to conduct as my co-chair is absent today. So at 10 a.m. I will be departing whether this hearing is complete or not. So please forgive my absence. It's not a lack of interest. It's simply having to be in two places at once. And I'm very pleased to present to you today LD 1008, an act to require joint use entities to establish permanent liaisons with all county emergency management agencies. This bill arose out of conversations among the Saginaw County delegation in regard to a bill this committee passed into law last session, LD 372, an act to increase the safety of municipal residents by allowing municipalities to address downed wires in extended power outages, sponsored by Representative Jay McCreight. There was a liaison established as a result of that bill between Central Maine Power and our county emergency management agency, and that has been very successful for both parties. It has cut down on the number of calls to CMP from municipalities and fire departments following a storm or accident, and centralized those calls with county emergency operations. And for emergency management, having one number to call 24/7 is enormously helpful in getting downed electrical wires dealt with rapidly. However, as you know, telephone poles carry more than electrical wires. Their very name tells us that. When a windstorm, ice storm, heavy snowstorm, or vehicle crash brings wires down off a pole, it may be difficult for the local fire department to judge whether it is a hot electrical wire, a telephone wire, or a cable television wire. Because remember, no wire is safe to touch ever. Roads may be blocked by such a downed wire, and if it belongs to an entity that has not yet been required to establish a liaison with the EMA, it can take quite a bit of time to identify the wire and have it removed from the roadway. From the point of view of individual consumers of the services of joint use entities, these services may be just as essential as power. For older Mainers living in rural areas, not having landline telephone services for several days can pose a real danger. For small home-based or rural businesses, the loss of phone lines or of internet can cause serious business disruption. There may be no one that is available to speak to during non-business hours in an emergency. And regarding the wires that provide this phone or internet service, let's ensure that our emergency managers have someone to contact at night and on weekends for these situations so that they can be addressed with the rapidity that they deserve. Thank you for your time, and I am happy to answer any questions, although there are those who will testify after me who may be more adroit technically. Thank you for your time.
Thank you, Representative Tessler. Representative Tepler. That was a throwback to an ancient time when I was served with Representative Tessler. Any questions for Representative Tepler? I don't see any hands up, though. Okay, good. So thank you very much. We'll now go on to proponents. There are no co-sponsors who have signed up to testify. So we'll go on to proponents. And
excuse me, Senator. Quite a few of my co-sponsors have submitted written testimony.
Okay, thank you. And as I said, committee members do frequently look at that. I mean, I say almost all the time they will review that. So thank you. We'll now hear from Barry Hobbins, speaking in favor. Morning, Barry.
Good morning, Senator Lawrence, Representative Barry, and members of the Energy, Utilities, and Technology Committee. I'm Barry Hobbins, and I'm here today to testify in strong support of LD 1008, an act to require joint use entities to establish permanent liaisons with all county emergency management agencies. The Office of the Public Advocate would like to thank Representative Tepler for submitting this bill. We believe that open lines of communications between joint use entities and emergency management agencies in every county is long overdue. Having support structures in place will expedite communications between these agencies and utilities and other service providers mentioned in the bill will go along with minimizing the negative impact of civil emergencies in the aftermath of natural disasters. The establishment of these liaisons will also result in a more streamlined chain of communication between the counties and these entities, which eliminate redundancy when customers of the entities need it most. To have the system in place before the next emergency will be a benefit to all ratepayers in our state. Before I sign off, it might be a consideration of, because of my last sentence, the necessity of getting this in place as quick as possible in order to avoid some type of negative impact if we have another significant event, storm event. So possibly putting an emergency preamble on this bill. I don't think that would be controversial. This bill, I believe, would have strong support, and that's a consideration. So I'd be more than happy to answer any questions, or I'll be available. My office will be available during the work session. Thank you very much.
Thank you very much, Barry. Are there questions from the committee for the public advocate? Seeing none, thank you. We'll continue with proponents. We'll go to Christopher Cummings of Woolwich, speaking in favor. Christopher?
Hi there, how are you today?
Good.
So I'm Chris Cummings. I live in the town of Woolwich, but my full-time job is I'm Deputy Fire Chief for the City of Bath Fire and Rescue Department. And I'm here today to testify in support of LD 1008 because over the year, outages and it's affected statewide. We could be on the scene of down power lines that are considered dangerous for hours, up to 10, 12 hours. And we've done this a couple times over the years where a CMP liaison has come to EMA. We prioritize the places that we need taken care of first, and so that we can redirect personnel to more serious scenes. As you know, there's a firefighter shortage. So, you know, a lot of times when you have a windstorm, a hurricane, things of that nature, a nor'easter, there are multiple calls going at the same time, which sometimes we have to prioritize and, you know, go to when we can. So this helps us because our main concern during a windstorm is, I know that CMP is busy, is to reopen the road so we can get emergency or police services to that location, and or if we have to relocate anybody, we can do that. And there's a lot of places in my area where there's only one way in and one way out. So one example would be the town of Georgetown. We had a windstorm about 12, 13 years ago, and they had a medical call at the end of that road. Due to the damage and the trees and power lines down, it took us almost 6 hours to reach that patient because it was unsafe to travel through and there was no other way. So like I said, a couple of years ago, we had a liaison in place and it drastically cut down the time that we were on scene with down power lines and blocked roads. And then we work on power restoration because CMP is dealing with 1,000, you know, could be hundreds of calls during a windstorm. So it's a great benefit to us and EMA. So I'm in favor of it. Thank you very much.
Thank you. Now, you said you're Deputy Chief of the Fire Department, is that correct?
Yes, sir.
Okay. And are you speaking on behalf of the Fire Department?
I am.
Okay. And are you speaking on behalf of any other organization like an association of fire departments?
No, I could be representing the city of Bath because we seem to have a lot of outages. You know, when the windstorms, we have a lot of outages compared to other towns.
Okay. I just have to make sure I know who you're testifying on behalf of.
Yes, sir.
For the record. Okay. Are there any questions for Deputy Chief Cummings from the committee? I don't see any. Thank you very much for coming, Deputy Chief Cummings. We'll now go on to Vanessa Corson from the Maine Emergency Management Agency, speaking in favor.
Good morning. Can you hear me?
We can hear you fine.
Senator Lawrence, Representative Berry, and distinguished members of the Committee on Energy, Utilities, and Technology. My name is Vanessa Corson. I'm the Legislative Liaison and Public Information Officer for Maine Emergency Management Agency. I'm here to provide testimony in support of LD 1008, an act to require joint use entities to establish permanent liaisons with all county emergency management agencies. This legislation requires joint use entities like telecommunications service providers, public utilities, voice service providers, unlit and dark fiber providers, information service providers, and wholesale or retail competitive local exchange carriers to establish liaisons in any of Maine's 16 counties where the company has a facility. The liaison is responsible for communicating and assisting during a disaster or civil emergency. Take the windstorm of October 2017, for example. As a result of that disaster, downed wires made some roads impassable for several days in counties across the state. Even when electric utilities dispatched crews to repair their own lines, those companies are not allowed to remove downed lines owned by other entities. This resulted in some roads remaining blocked for an extended period of time without recourse, since several of the entities in question did not provide timely contact information to emergency response partners. This delay could be devastating if emergency vehicles were unable to get through to respond to a life-threatening incident. Maine Emergency Management Agency feels it is necessary to establish and maintain ongoing relationships with these entities, not just one that would be initiated in a crisis, but one that could be strengthened in advance of disasters through training and exercise activities. There's an old saying in emergency management, a disaster is the wrong time to exchange business cards. Finally, MEMA would like to recommend that each county is given the choice of whether the liaisons for these entities are physically located in their emergency operations center during disasters, or if they would like them as virtual partners. This concludes my testimony, and I'm standing by for any questions you may have. Thank you.
Thank you very much. Are there questions from the committee for Ms. Corson? Seeing none, thank you very much.
Thank you.
We will continue with our testimony of individuals in favor of this bill, and we'll go on to Garrett Corbin of the Public Utilities Commission. Garrett?
Yes, good morning, Senator Lawrence, Representative Berry, and members of the committee. Garrett Corbin just beamed up here on behalf of the Public Utilities Commission in an unusual posture, speaking in favor, of this legislation. The 1008 enact to require joint use entities to establish permanent liaisons with all county emergency management agencies. The Commission supports this legislation as we believe it will improve communications between emergency management agencies, transmission distribution utilities, and all other utilities. Commission staff support the Maine Emergency Management Agency when major storms impact utility customers. We've seen firsthand how enhanced communication and coordination improve restoration efforts and improve safety issues associated with these events. The Commission also understands, and as we just heard, MEMA supports this legislation as well. By way of background, the Commission provides the following a few pieces of information on activities related to this bill. Just to back up to December of 2017, when the Commission opened an investigation to gather information on T&D utilities preparedness in response to that October 2017 storm that caused several outages statewide. The Commission's order on docket number 2017-00324 in that case noted a lack of coordinated, commonly understood, and consistently followed set of protocols for information exchange and activity responsibility among the utilities, municipalities, county EMAs, and MEMA. That appeared to result in delays in addressing unsafe conditions such as wires in the road, making roads passable, and generally introduce uncertainties and inefficiencies that may have impeded restoration efforts. That may not be the, well, we had active participation in all MEMA calls during storms from the two investor-owned T&D utilities, CMP and Versant. Both of those utilities have expressed a desire to improve coordination and have, as far as we can tell, done so coordinating with county EMAs during storm events, but that might not be the case with all utilities. Because utility poles and equipment are often jointly owned, it's sometimes necessary to contact other utilities, and some of them currently no formal contact with state or municipal agencies. In some cases, the T&D utility is pole replacement and maintenance responsibility. In other cases, the duty lies with the telecommunications or cable company that owns the pole. So the commission noted in that order cited previously that inefficient communications between T&D utilities and the telecommunications companies were likely the cause of significant restoration delays. So for these reasons, the commission again supports this legislation, and we're available to answer any questions and happy to participate in any work session.
Thank you very much, Mr. Corbin. Are there any questions from the committee? Seeing none, thank you. We'll now go on to our last person speaking in favor, Bradley Sawyer from the Maine Rural Water Association. Bradley?
Thank you very much, Senator Lawrence, Representative Barry, and members of the committee. My name is Brad Sawyer. I'm a resident of Augusta, and I'm here speaking on behalf of the Maine Rural Water Association. To Senator Lawrence's comments before the committee started, I won't read my testimony and just state that the discussion so far is evidence of water utilities' desire to be for this legislation to go through. We are often forgotten about until water isn't showing up or wastewater is showing up. And having these contacts in place beforehand will help everyone and certainly strengthen the response in a disaster. So the rural water community believes that this is a good bill and urges your support. Thank you very much.
Great. Thank you very much, Brad. You win the award today for conciseness and consistency. So we appreciate that, and we will look at your written testimony. Are there
always good to get a win, Senator?
Are there questions from the committee? Seeing none, thank you. Jordan, this completes my list. I just want to make sure there's no one else who has signed up at the last minute.
I believe that is it for 1008.
Good. Then I will declare the public hearing on LD 1008 closed. We'll now go on to our next bill, which is LD 1130, an act to establish a public registry for automated telephone calls and so-called robocalls. I'm looking, do we have Representative O'Neill here yet?
Representative O'Neill is coming from another committee hearing at the moment. She should be on shortly. I just sent her the Zoom link, so it might just be a minute.
Okay. So we'll just take a minute and wait for her to join us. Does anybody want to play the theme from Jeopardy on their phone?
She's being promoted now.
Okay, great. Representative O'Neill, you have the floor to present your bill.
Thank you, Mr. Chair. All right, just getting situated. Didn't leave my chair, but leaving Zoom rooms. All right. Thanks for your patience. All right. Good afternoon, Senator Lawrence, or good morning, Senator Lawrence, Representative Barry, and members of the Energy and Utilities and Technology Committee. My name is Maggie O'Neill, and I'm here representing House District 15, which is in Saco. I'm here to present a bill that essentially would make a registry of robocall contractors and folks who engage in those practices. So everybody knows that robocalls are a pain in the neck. In the past few years, some telemarketers have used technology to bombard consumers with hundreds of millions of pre-recorded calls that are often unwanted and frequently deceptive. I can hardly answer my phone without getting one of these calls. I'm sure it's the same for you. For background, I put this bill in after a conversation with a constituent who doesn't hate robocalls and texts. I happened to be working on another bill that had some overlaps, and then kind of came up with this idea as a solution because it seemed like a parallel problem that we could solve. So as you know, currently we have a federal do not call list under the TCPA, the Telephone Consumer Protection Act. Before making calls, telemarketers have to consult with that DNC list. They also have to maintain their own internal do not call lists. As a note, Mainers can easily determine whether they're on the federal DNC list, but that federal DNC list is limited. Even if a person signs up for the list, many entities are still able to contact them. For other tools, carriers have blocking tools. The FTC advises us not to answer if we don't know the caller or to hang up right away. And although we have this framework in place, consumers are still bombarded by unwanted and sometimes deceptive calls. That's where this bill comes in. To solve the problem with robocalls, we need to know who it is that's engaging in these practices. So this bill would allow consumers to take a first step against the torrent of phone calls that we receive by identifying the companies who are facilitating those calls. This registry would serve as an information gathering tool, a tool that Mainers can use to battle the onslaught of unwanted calls. The privacy interest at the heart of this legislation is really the right to seclusion. Each of us has a privacy interest in avoiding harassment and annoyance. To borrow phrasing that Senator Stewart will recognize from Warren and Brandeis, we could describe this privacy interest as the right to be let alone. This bill would give Maine residents a tool to protect that right to be let alone. So here's what the bill does. It's simple in structure. It creates a registry for companies who personally or through contractors make robocalls or use automatic dialing systems to call Maine residents. The registry would apply to both in-house and subcontracted services. It would allow for data mapping of companies who engage in or contract for these services to reach Maine consumers. Should we enact this bill, entities who use or contract for robocalls will be required to fill out a simple form identifying themselves. Here's what it won't do. It won't make companies identify the residents that they'll call. It won't make them identify the numbers that they're going to use, and it won't make them identify the speech that they'll engage in. It just requires them to identify themselves. So this simple form will pave the way for residents to be more at peace and secure in the calls that they receive. So to recap, LD 1130, it wouldn't limit a company from using robocall systems, and it wouldn't impede their message or speech in any way. Rather, it would allow Maine residents to identify entities that call them. So that identification can be useful, like I said, for data mapping, and it can allow us as Mainers to withdraw our consent if you wanted to go through and add yourself to do not call us with these companies. You could update your information, you could change your communication preferences with the entity. So the registry will really be a tool at our disposal just to lessen the onslaught of obnoxious, constant, and even harassing calls that we receive. And I want to make a note, I'm sure you're aware, but just last week I read an article saying that robocalls may get worse soon. Last Thursday, the Supreme Court issued an opinion in the Facebook case that narrowed the scope of the TCPA. As you know, Congress enacted the TCPA in 1991, predating modern auto dialing technology. And the goal of that legislation was to protect consumers from hounding by telemarketers, reducing the number of unwanted telemarketing communications that we receive as consumers. It protects the privacy interests of residential telephone and now cell phone users by placing certain restrictions on the use of unsolicited automated phone calls. Among its restrictions are a prohibition on using an automatic or artificial pre-recorded voice to make any calls without the express prior consent of the called party, or for emergency purposes, and it includes other exemptions. Some advocates are saying that this Facebook case undid decades of work by Congress to shield Americans from automated phone calls. Under the CPA, the court can choose to accept a narrow view, the court chose to accept a narrow view of what constitutes an auto dialer, also known as an automatic telephone dialing system, ATDS, limiting the definition of systems that target sequentially or randomly dialed numbers. So that means companies can use automated dialing systems as long as they don't generate numbers randomly. The chances of getting caught breaking the rule are also slim. And just for background, if you're curious, the facts of the case centered around a man who was not a Facebook user and had never actually created an account, who was receiving unwanted texts from Facebook. And he went through the channels offered by Facebook to stop receiving the messages, but he didn't have any luck stopping the texts after repeated efforts. So at some point he got fed up and filed suit under consumer protection statutes. And Facebook fought the suit instead of working with him to resolve the problem. And that's why we have the outcome that we had last week. So it's very much a live issue that may get worse without action from Congress. So just with that note on current events, in the meantime, what we can do in Maine is take a step forward to protect Maine consumers by creating a registry of companies who make robocalls or who subcontract for them. If consumers want to take action to stop the torrent of phone calls, they first need to figure out who is contacting them with an automated system. So this registry will really allow consumers to take that first step and identify those companies. And it'll allow Mainers to be more at peace and secure in the calls they receive. Thanks for your attention, and I'm here for questions.
Great. Are there any questions for Representative O'Neill? Seeing none, Representative, are you in your last year of law school?
No, second, about halfway.
Second. So we all want to know if Senator Stewart is a diligent and attentive student to his law school duties, because he's in committee an awful lot.
Of course. We can walk and chew gum, right, Senator Stewart?
Absolutely, yes.
Good, good. Well, best wishes in law school. We'll go on to our next person. Testifying against the bill is going to be Garrett Corbin from the Public Utilities Commission. Garrett?
Good morning again, Senator Lawrence, Representative Berry, and members of the committee. I'm Garrett Corbin, legislative liaison for the Maine Public Utilities Commission. Again, in a rare neither for nor against position, testifying against LD 1130. And let me first say that we do appreciate where Representative O'Neill is coming from. We do hear her. The opposition to this has much less to do with the substance or the issue that she's trying to address, and just the question of jurisdiction. So the commission's, we just raised questions of whether first the PUC is the optimal location for the registry, and then also whether the PUC or the state of Maine would have jurisdiction over or maybe preempted from enforcing this proposal. The commission's aware that primarily this issue is a matter of federal jurisdiction, not only as a result of federal law, but also the reality that many of the calls that are being made are made at the direction of out-of-state or even international service providers and marketing entities. The FCC's Wireline Competition Bureau is currently working on the North American Numbering Council's Call Authentication Trust Anchor Working Group, that's a mouthful, to implement the federal statute, and their efforts right now are on track to deliver results called for by Congress in recently enacted federal law. So our written testimony notes the key technical challenges being worked on actively at the moment at the federal level. And then at the state level, while the commission does, we do retain jurisdiction over what's called provider of last resort polar telecommunication service. Other state agencies have more traditionally been vested with Consumer Protection Enforcement Authority, and the commission, of course, or the committee has dealt with this in other bills recently. So Title 10, Section 1499A, for instance, considers telemarketing malfeasance. be a violation of the Unfair Trade Practices Act that's in Title V, subject to enforcement by the Maine Office of the Attorney General. And we want to point out that although the commission regulates utilities, we do not necessarily regulate entities that use utilities in violation of other laws of general applicability. Whether or not the commission's ultimately designated with responsibility for this automated call registry, should the proposal move forward, the commission recommends adding some detail to the term commercial purpose that's used on lines 5 and 14 of the bill. For example, a question came up as to whether pharmacies, which many of us know, use automated calls to let customers or patients know that their prescription's ready. Whether or not that's really intended to be addressed, it would probably fall under this as described in the language. Then we'd want to clarify the logistics of enforcement. Right now, we lack the technological and other legal mechanisms to determine which entities control the lines making the calls. We don't have the tools to compel compliance if the entities outside of Maine so I sense I'm approaching the 3 minutes, so we've got a little bit more in the testimony, but I think that hopefully addresses the main point again is that regulation and enforcement of robocalls is a difficult issue across jurisdictions. It's been recognized as such, and it's a matter under active consideration at the federal level, both the FCC and in Congress. So with that, I welcome any questions and will be present for the work session.
Thank you very much, Garrett. Are there questions from the committee? Yes, Representative Foster.
Thank you, Mr. Chair, and thank you, Mr. Corbett, for your testimony. I too agree with the substance of Representative O'Neill's bill here. But my question is, when I get my daily call from some number in Montana, which I refuse to answer, is that one that the PUC would be able to recognize and regulate as directed by this bill? Thank you.
Thanks for the question, Representative Foster. And no, that's correct. That's the part of our point is right now we need additional technical capacity to carry this out. The best we could do right now is to try to determine who the provider might have been and ask them for information. But even that would probably be slow going. So, but you never know who that could be calling. So you might want to check it one of these days just to make sure that it's not a friend in Montana and that it is a telemarketer.
Thank you. If I may, well, if I may, I will only say that they can always leave a message.
Yeah. Other questions for the PUC? Seeing none, thank you. We will now turn to people testifying neither for nor against this legislation. And we'll go on to Benjamin Sanborn of the Telecommunications Association of Maine.
Hello, thank you. I'm sorry, I have to rearrange windows here. My name is Ben Sanborn. I'm the Executive Director and Counsel for Telecommunications Association of Maine. Thank you, Senator Lawrence and Representative Berry, members of the committee. I'm here to testify neither for nor against. I think our comments are somewhat in line with what Mr. Corbin was discussing. We don't actually have an opinion of if it moves forward or not. We agree that robocalls are a problem, and we are working through national organizations to try and address them at the federal level. If there are additional things that the state can do, we're not necessarily opposed to that. The one thing that we wanted to point out in this specific legislation had to do with some of the exceptions that exist at the federal level, and specifically the issue of regulated utilities. We do have circumstances in which we will, for example, use an automated call to remind an individual that a technician is coming out to work on a service or something like that. And while we are utilizing these types of services, we're doing so within the regulatory confines of what's permitted by the commission, existing business connections, and federal obligations as well. For example, if our affiliate offering broadband is doing something similar, there are regulatory structures around what they can and can't do. And more to the point, we're pretty easy to find. And it's pretty straightforward for the commission to be able to bring us in if we're doing something that a customer believes is inappropriate. So for that reason, if the committee does move forward on this legislation, we would urge that there be a specific exemption for any entities that are public utilities or that are regulated at the state or federal level in the provisioning of services to the customers. And with that, I'm happy to take any questions.
Thank you very much. Are there questions from the committee for Mr. Sanborn? Seeing none, thank you very much.
Thank you.
We'll continue with our individuals testifying, our organizations testifying neither for nor against, and we'll go on to our public advocate, Barry Hobbins. Give him a second.
Thank you very much. Sorry about that. Bad connection, I guess.
Yeah.
Good morning. This is Barry Hobbins. I'm public advocate. Senator Lawrence, Representative Barry, and members of the committee. I am testifying neither for nor against LD 1130. I commend those who are involved in the political arena, in the public policy arena, and trying to address these particular issues. Ironically, the legislation that Representative O'Neill, who's one of the legislators from Saco, I'm proud to say, my hometown, brought up a good talking point, and I think it's for a good discussion. I believe, though, that the Public Utilities Commission has made some strong arguments, which I think will be a problem potentially when it comes to federal preemption. The FCC has taken a strong proactive approach during the last couple of years. The FCC has a wireline competition bureau, and that bureau is working with the North American Numbering Council Call Authorization Trust Anchor Working Group to implement the federal law and the federal statute and to look at the issue in general. Interestingly enough, I was appointed by former Chairman Pai to serve as the Nasuka representative as a member of the North American Numbering Council for the last 3 years. And also, fortunately, the vice chair of the Numbering Council is Commissioner Williamson, who represents NARUC, which is the National Association of Regulatory Utility Commissioners. So we do have at least an input through the Numbering Council with issues like this. My concern is that I think it needs warranting to look at whether or not we can establish something somewhere to act as a liaison with the federal law. Now, I understand that the 2 United States senators have many issues involving this that are brought to their attention, and have been very proactive in the United States Senate in looking at legislation. I'm sure that's the same case with our 2 members of Congress in the House. So I'm very pleased that we're looking at this issue, but I really forewarn you that I believe that the only jurisdiction we have would be through the situation involving local carriers and the provider of last resort. I don't believe that Representative Foster brought up a good point. I think we'd have a problem trying to enforce any type of action against that caller from whatever state it is. So that's my comments. I really commend Representative O'Neill for taking this on. It's a very important issue, and we should follow it. I know I am as a member of the Numbering Council. Thank you.
Thank you very much. Are there questions from the committee for the public advocate? Seeing none, thank you very
Thank
much.
you very
Barry,
much.
for testifying. We'll now go on to our last individual testifying neither for nor against, who is Ellen Parent from the Maine Credit Union League. Ellen?
Good morning, Senator Lawrence, Representative Barry. I'm here representing the Maine Credit Union League. I'm a resident of Portland, and we are testifying neither for nor against. I won't burden you with reading my written testimony, but I would encourage the committee to read the opinion in Facebook v. Dogood. It came out last week, and we would ask that you consider this new definition, or this narrowing of the definition, if you adopt any legislation here. There are plenty of good reasons for sending automatic messages that are permitted under the law, and we would like to have that maintained. For credit unions, it's often things like there's been suspicious activity outside of your geographic area, or something like your credit card has been declined. Things like that are important to our members, and we'd like to maintain that. Really every cell phone has the capability of being an automatic dialer. Your personal cell phone can, even your personal landline likely, can store phone numbers and automatically dial them. So the idea that this is narrowing it impermissibly is, I think you can see from the decision in the case, is not accurate. And I think there is certainly something to be said. None of us like the phone calls that we get. The car warranty is I hear it's been expired, but these calls are probably not the ones that Maine can regulate. And so we'd like to just ask you to use caution and be sure to not cut off any reasonable and normal forms of business communication. Thank you.
Thank you very much. Are there questions from the committee for Ms. Parent? Seeing none, thank you very much. Jordan, are we all done with people testifying on this bill?
I believe so, yes.
Okay, great. Super. So I will close the public hearing on this bill, and we'll now move on to our next legislation. And has Representative Barry rejoined us? I see you there.
I have.
Representative Barry. We'll go on to LD 933, an act to facilitate the expansion of broadband to unserved areas of the state. Chair recognizes the sponsor, our very own Representative Barry.
Great, thank you very much, Senator Lawrence, members of the committee, good to be with you. To present LD 933, an act to facilitate the expansion of broadband to unserved areas of the state. As you know, I am Seth Berry, and I represent House District 55, Bodenham, almost all of Richmond, and beautiful Swan Island on the Kennebec. Today, I want to specifically address an amendment sent out last night that would clarify the intent of the bill. It actually makes it a resolve rather than an act, and would, I hope, just serve to advance this larger conversation. It's so important about broadband access in particularly rural, unserved parts of Maine. And I think that the best way of understanding what I'm trying to accomplish here is to dial the clock back 100 years and remember when a third of America did not have electricity. We solved that problem by socializing or sharing the costs of the grid, and we continue to do that today. We require CMP, for example, one of our utilities, only one of 10 or so, to charge the same rate in Caratunk as they charge in Kennebunkport. Caratunk is much more expensive to serve. There are many more miles of wire, many more poles per customer, many more transformers, substations, et cetera. So the expense of serving a rural area is much greater, but we charge everyone the same rate. And we do that in part through the regulated tariff rates that are set at the Public Utilities Commission. You might ask if this is fair to Kennebunkport, if charging the same rate in Kennebunkport is fair to Kennebunkport as charging the same rate in Caratunk, because Kennebunkport is cheaper to serve. You know, why not allow those residents to pay less? Well, I think it is fair to Kennebunkport. I want you to imagine a nation where we failed to charge equitable rates and to share these costs equitably. We might still lack electricity in many rural areas had we not shared these costs. We might even be what we call a developing nation had we not done this as a country 100 years ago. A specific example here in Maine of socialization of costs for T&Ds was also where Swans Island, not Swan Island, but Swans Island joined Emera Maine, which of course is now Versant. The PUC allowed Versant to absorb the Swans Island Electric Co-op and socialize the high costs to serve this rural offshore island utility that has an expensive undersea cable. So that absorbing them essentially meant a subsidy and a cost shift to the others in the Versant territory. That has worked out very favorably for Swans Island. You know, their rates have come down, understandably. Versant customers are paying a little more, but it's a tiny bit more. They don't notice the incremental increase in their bills and much less complain about it. So this tends to work very well for rural areas, and urban areas, generally speaking, are not overly burdened by this effort to make electricity universal. What I'm trying to do here is consider whether we could, in our pole attachment and make-ready cost allocation, do something similar for broadband. It's a little more complicated in the broadband world because there's not a single provider, as with electricity. We don't set rates for internet at the PUC. But there is one part of the system which is both shared and regulated, and that is our utility poles. Our poles are owned by incumbents like Consolidated and Central Maine Power, for example, as well as our smaller ILECs and T&Ds. And as regulated utilities, pole owners are compensated for all expenses. They're also provided a return on their capital investment. And it just so happens that to bring high-speed internet to the entire state, to many parts of Maine, roughly 85,000 homes and businesses that do not have service that's at least 25.3, we must have fiber optic cable on the poles. That's true for every part of our delivery system. If you want wireless, you need fiber backhaul attached to the poles. If you want satellite, you need fiber backhaul attached to the poles. If you want 5G, you need fiber backhaul attached to the poles. And maybe if you're lucky, you can even get fiber directly to your home or business. I was fortunate enough to have that happen this summer, thanks in part to Connect Maine and to local and private efforts. Fiber is really the gold standard. It is future-proof, or often referred to that way. And the more of it that we can attach to poles, especially in unserved areas, the better. So the point here is poles. Everything needs fiber, and fiber needs poles. It just so happens that one of the biggest costs of attaching to poles is make-ready costs, moving the facilities around on the poles, perhaps even replacing poles so they're taller, to make it possible for this fiber to be attached. And in unserved areas, we are told and have been told, this committee has been told for many years by providers, that it is 25 to 40% of the cost of their build out in the unserved areas, simply to make the poles ready and to attach to those poles. 25 to 40% of the cost is that make ready and pole attachment cost. There are also delays involved in that, and there will be other bills that we take up this year that try to address the delay issue. But the cost issue that's involved, the make ready cost issue and the pole attachment cost issue, is substantial. And this bill would, as I propose it, change to a resolve and ask the Public Utilities Commission to take a look at what's happening in Georgia, for example, where the Georgia Public Services Commission, their equivalent of our PUC, has adopted what they call a buck a pole, which is to say that the cost of attaching to poles in rural areas will be $1 per pole for the first 6 years. And that's only for unserved areas. And then the incremental cost that would have been absorbed by the provider in those unserved areas will be taken up in other pole attachment rates. So just like we do with electricity, we would be sort of sharing in the cost, making the deployment of rural broadband a priority, and just as we did with electricity and still do today, and using that pole attachment rate as the means by which to do it. So we wouldn't be using tax dollars. We'd be just sharing costs differently within our current make ready and pole attachment rates. And the PUC, and they'll speak to it today, is engaged in very important conversations already, very important dockets around pole attachment and make ready. I understand there's some great new inquiries that they're going to be taking up very soon. And I think this is an important part of that conversation that really needs to go forward. You know, can we learn from Georgia? Can we maybe even do our own thing here around make ready costs, share those in a way that ensures that without the use of tax dollars, that we can actually bring down that 25 to 40% of the cost which make ready involves. So the amendment would change the bill to a resolve. It would clarify that the PUC, as the study directed in the bill, must include a review of methods of promoting broadband expansion in unserved areas through a limited period reduction in the costs of utility pole make ready work, as well as the limited period reduction in utility pole attachment rates as proposed in the underlying bill. Again, apologies to those stakeholders who came today prepared to testify on the underlying bill. I'd hoped to have that amendment out sooner than last night, so I'm happy to engage in any questions or clarifications that may be necessary. I want to thank our legislative analyst, Dan Tartikoff, for helping me to put that amendment together. Thanks for your time, and I'm happy to try to answer any questions.
Other questions from the committee for Representative Berry? Representative Grochowski.
Thank you, Mr. Chair. Thank you, Representative Berry, for posing this possible path forward to learning more about the options for reducing the costs. I just wanted to clarify my memory. I was jogging my memory here about similar work we did last year. That was a bill from Senator Vitelli, where I think, I just tried to look it up and found that in the case of a municipality attaching to a pole in an unserved or underserved area, that the cost would be kept by the owner of the pole and each entity attaching to that pole if they were going to provide broadband service to those underserved areas. So do you know if that has been utilized at all? And do you see this as like a broadening or a look at how effective that has been in a broadening of that for non-municipal installations of broadband?
Thank you, Representative Grochowski, for the question. And yes, I think the latter phrasing is correct. This would really allow us to get a fuller accounting of how that proposition has evolved. I don't think that there have been too many direct efforts to use that new provision of statute, but I think that may change. We're obviously going to see a real acceleration of broadband with those one-time, and I emphasize one-time federal monies. This is really an effort to try to create a system that outlasts those one-time monies and that maximizes those one-time monies. We did provide municipalities with a similar sort of special treatment. But I think, frankly, that a private pole attacher who is looking to serve an unserved area should also, have some degree of similar, treatment and reduction of costs. So I think, yes, the goal is to understand that, as well as what's going on in other states and how we can better allocate these costs.
Thank you very much. Are you all set, Representative Grochowski? Okay. Other questions? Representative Foster.
Thank you, Mr. Chair, and thank you, Representative Berry, for your presentation of this bill. Representative Grochowski and I believe, both had recollection of the bill that we addressed in the 129th, and certainly when we talk about broadband and whether it's spreading money, the cost out to serve rural areas to taxpayers through grants or federal dollars, or through ratepayers from some method that might be used. My recollection in the 129th, and I'm wondering if you could speak to how you square the bill that we're talking about now, or resolve, as it reflects on what we did in the 129th, which at the time I spoke in opposition to the bill. And just as an example, we had the town of Islesboro, who had decided on their own they could afford the costs of making ready the poles for their expansion of broadband in their community, which was, if I remember right, at least hundreds of thousands of dollars. At the time, that bill, which they had already done that project, so it wasn't them, but that bill made it so that another community doing that, the costs of the make ready would not be charged to them, but would be passed to all other ratepayers, including those constituents of mine who would like to have broadband or may have that service, and which would be reflected in higher rates for all of us. So I'm just wondering if you can tell me how you square this bill against what was passed in that previous legislation. Thank you.
Sure. Thank you, Representative Foster, for that excellent question. And I think that we did, as has been referenced, take some important steps to allow municipal pole attachment for municipal purposes to be able to attach to infrastructure that is, after all, in the municipal public right of way, to be treated differently. But that doesn't, it's my understanding that what we did was really just a partial measure, and has not been fully able to rise to the challenge that we face. As I mentioned, 85,000 homes and businesses in Maine, including the ones that you referenced in your own district, Representative, are without adequate service. So under 25.3, which is arguably even too low a standard now. The idea here would be to bring down the cost of make ready and pole attachment for those who are attaching to poles, to provide your constituents finally with adequate service that we believe everyone should have, and to very, very incrementally adjust pole attachment costs, not make ready, but ongoing pole attachment costs for all other customers. So that would be everyone that I represent, all of my constituents, except there's one dairy farmer who's currently unserved, would pay, presumably slightly more. That cost might be passed on, just as it is in our electricity rates right now. But it would be spread out over time, because pole attachment rates are not a one and done like make ready. They're spread out. And, I think that our PUC can figure out a way to do this sort of thing. It's what they do in utility rate setting already. And I also want to point out, Representative, that the way that we currently are trying to bring broadband to your constituents who don't currently have it, and to my one dairy farm, is tax dollars. That's also socializing the cost, right? If it's federal money, that's tax money. If it's a state bond, that's tax money. So we are already socializing this cost. And anybody who comes to talk about this bill and says, oh, you can't do that because that's like a tax. Yeah, well, I'm sorry, that's what it takes money to get the broadband to these rural areas. These projects do not pencil out unless we help them to pencil out. We're not going to get there. We have a broadband plan. It's going to cost us $600 million in some kind of public dollars, even if we are only doing a quarter of it and asking the private sector and local leaders to come up with the rest. So I think this might be a way to get it done that is more logical, more equitable, and more lasting than our current tax-supported approach.
Any follow-up, Representative Foster? Okay. Senator Vitelli.
Thank you, Senator Lawrence, and thank you, Representative Berry, for bringing this bill forward. I don't have a question, but I did want to answer a question that was brought up by Representative Grohowski earlier, which is that I just wanted to let you know that the town of Aroustic, which is working on developing its own Aroustic broadband company, is very much in the process today in establishing the pole make ready process. We're counting the poles in town so that we can make the attachment and establish broadband service for every resident in the town of Aroustic who chooses that. It's being funded by both public and private sources. And I just wanted to let you know that the Make Ready bill that I sponsored last time is in fact going to be tested or implemented very shortly.
Great, thank you, Senator. Any questions for Representative Berry? Seeing none, thank you very much.
Thank you.
We'll go on to, we have no proponents of the bill, so we'll go on to those testifying against the bill. And I'll recognize again Benjamin Sanborn of the Telecommunications Association of Maine. You just need to unmute.
There we go. Sorry. Thank you, Senator Lawrence, Representative Berry, members of the committee. My name is Ben Sanborn. I am the Executive Director and Counsel for Telecommunications Association of Maine. We do come forward today in opposition to this legislation. The testimony that we submitted in writing was with regard to the bill as initially drafted. However, we don't substantially change our position based on the amendment because essentially our position is this is something that is currently being looked at by the commission. This is a multi-stage process on joint use of poles, and we're well on the way to getting to a fourth stage, a phase 4, where we're going to be discussing the implementation of a joint use system for attachment in order to allow people to more quickly deal with how exactly they're going to be getting their equipment moved on a pole. And I think it's an important step back here to note that the majority of what costs are for Make Ready is labor. It's people going out to the poles and checking and seeing what's on the poles, what needs to move, how to move it, getting people there to move it. And that's exactly what the commission has been addressing in their multi-stage process here. The most recent phase was moving to a one-touch Make Ready approach, which is going to help streamline this. The next is to have a computerized system. So instead of having delays where people are trying to say, well, do I have something that needs to move to? When you're done, you put in the system checks it off and automatically notifies the next person. This is something that's done nationwide, and you can streamline this, which again, reduces time, reduces costs, reduces Make Ready. And at the end of the day, this is all necessary for safety. Because if you don't do sufficient Make Ready, you can easily have somebody go up there, put the wrong tension on a pole comes down in a heavy windstorm, and someone dies. I mean, we had unfortunate accidents very recently with regards to people being struck just while they're driving. And that is what we're really trying to protect here, making sure that we can balance the needs of the individuals receiving the service with the needs of this safe and reliable network. And that's what Make Ready is for. And so we strongly support the idea of how do we address this to make sure it's streamlined, that there aren't any external costs that are going to be unnecessary, that are no longer needed in the structure. We think that a mandatory joint use system is critical, meaning everybody who is on a pole has to be a part of the system, everybody. And if that happens, then we can have a streamlined approach that will reduce make-ready costs. We believe that's the appropriate way to move forward. The commission is already doing this. We don't believe there's need for additional legislation. So with that, I am happy to answer any questions.
Great, thank you. Are there questions for Mr. Sanborn from the committee? Representative Grochowski.
Thank you, Mr. Chair. Mr. Sanborn, if you can answer this, or I can direct it to the PUC. Do you know when One Touch Make Ready is going to be made ready? Because I feel like we've been hearing about this for 2 years and maybe longer. And I'm super excited about it. I think it's very efficient use of resources, and I'm ready to go.
Thank you, Representative. I think it might be on deliberations today. They usually do deliberations on Tuesdays, and I think I saw that there was going to be a discussion of this. Mr. Corbin would certainly know for certain. I am getting a text message that yes, it's on today. So that is my understanding. So what will happen is this will go into effect, and then they will do an inquiry that is going to start the process of the joint use system, the JUN system, and we'll move into phase 4.
Great. Thank you very much. Other questions? Representative Foster.
Thank you, Mr. Chair, and thank you, Mr. Sanborn, for your testimony, Mike. I think something's wrong with my computer. I keep trying to make you larger than you appear on my screen. And from my recollection, it's not working. My question is, in regards to what you've just mentioned, do you find that this resolve is contrary to prior legislation in that, for instance, if the good people of Arousek do go through with their project, ratepayers in Garland, Maine are going to have to help pay for their make-ready costs because of previous legislation. However, this resolve would ask the good people of Arousek, once their system is in, to help the ratepayers in Garland with the pole attachment costs. I'm not sure if that eventually balances out, but I'm wondering if you might give me your thoughts on that. Thank you.
Sure. Thank you, Representative. Rate design is kind of a tricky thing, and it is always the balancing of how do you properly address the cost causer versus those who benefit from the existence of a network that reaches everybody. That was always the justification for both the electric and the telephone rate designs that would distribute costs so that, for example, in Portland, Maine, it may have only cost $5 to offer telephone service, but in Garland, Maine, it may have cost $75. And so instead you have a rate design that says we're going to make them charge $20 to everybody in the state. And so that was accomplished on the basis of the theory that having a communication system that connects everybody is in the best interest of everybody. And therefore there's a benefit that's being derived by the people of Portland by being able to contact people in Garland. And therefore it's appropriate public policy to distribute the costs of the network as a whole among the users of the network as a whole, even if it's not the actual cost causer who's bearing the burden. So that was the justification. It worked in a monopoly scenario, because in a monopoly scenario, it was NYNEX was providing, excuse me, service in Portland and service in Garland. And so it's very easy to say to this one company, sure, allocate your costs in such a way that you will be kept whole, and yet we will be able to make sure that people in Garland, Maine will be able to afford their service. When you don't have a monopoly situation, then it gets much harder, because now you're saying that there is a fixed benefit for the customers in Arousek that is not necessarily shared by the customers in Garland. And it is not the same entity who is serving the individuals in Garland. And it may not even be the same poll owners for Garland versus Arousek. And yet you're doing a rate design that is going to apportion the costs away from the cost causer and onto these other individuals. Is that proper policy? I think that's a question for the commission as a part of their joint use structure. It doesn't seem like it from our perspective. And I don't know that it's appropriate to sort of direct them to find that, since there is a real question as to whether there is that benefit to customers outside of Aroustic if Aroustic uses its own resources to give higher speed broadband to its own customers.
Any follow-up questions for Mr. Sanborn?
No, thank you, Mr. Sanborn.
Thank you. Any other questions from the committee for Mr. Sanborn? Seeing none, thank you very much, Benjamin, for joining us. We had scheduled Peggy Schaefer from DECD on schedule to testify against, but she was unable to join us in the attendees room. But she has submitted written testimony, which I would direct committee members' attention to. We'll then go on to individuals testifying neither for nor against, and the chair.
Mr. Chair.
Representative Berry.
Just for the record, that written testimony is not opposed to the bill. It is neither for nor against.
Okay, I apologize. She had signed up as against the legislation.
Yep.
The chair will go on to Barry Hobbins, who is testifying neither for nor against. And I see, perhaps accidentally, he got bumped out of the panelists, Jordan. So if you could load Barry and back in as a panelist, and also Garrett Corbin from the PUC in as a panelist, that would be great.
Yeah, I'm looking for Barry currently. I think he might have removed himself from the meeting entirely.
What I'll do is I'll go on to Garrett Corbin, and then if Barry Hobbins comes back, we'll go back to him as neither for nor against. So Garrett, you can proceed.
Okay, good morning again, Senator Lawrence, Representative Berry, and members of the committee. Garrett Corbin testifying neither for nor against LD 933 on behalf of the Maine Public Utilities Commission. I'm afraid Mr. Sanborn stole a bit of my thunder discussing the good things the commission is doing. Along these lines, I will get to that. Our written testimony, of course, responds to the printed bill, but I'd just like to start by addressing a few things that have come up so far. One is the question asked by Representative Grahowski about One Touch Make Ready, whether it's made ready. Appreciate that phrasing. And pretty serendipitous timing. The commissioners are deliberating that proposed rule, our Chapter 880 rule that would incorporate that in the state as we speak. Looks like they just finished. So as far as I know, it looks like that was just adopted within the last few minutes. And then another, as Mr. Sanborn had mentioned, the commission is also about to open a new inquiry to gather ideas and information regarding the implementation of a statewide database of polls and their attachments. The possible development of a centralized database with accurate information concerning the owner, location, condition of existing attachments on each poll could further speed up the survey work and make ready processes to reduce the time and costs associated with broadband expansion, in addition to being really useful during significant weather events that cause down wires and broken poles as well. The commission hopes that those actions, again, the adoption of the rule today and the inquiry we are likely to open in the near future, would help providers expand their networks more quickly and at reduced costs. With respect to the proposed study in the amended version of this bill as amended to be a resolve, as I understand it, I will try to follow up in writing with the committee on whether we have any more formal thoughts. But I think for now, I could say that I think it's safe to say we could likely shoehorn, so to speak, that proposal into the inquiry we're about to open. But again, I'll follow up in writing to confirm. So that is really all I have to say on this. So if you'd like to use the, sheep's tool to pull me off the stage here, I'm happy to stop. But I also have some things in the written testimony, just some background that might be helpful for the committee, just real quick. And again, stop me if I go too long, but just a couple observations that in our experience, the annual cost of attaching to poles, not as significant a factor in impeding broadband expansion as the two primary expenses incurred during expansion that adversely affect the ability of providers to reach rural areas. And I think the sponsor mentioned or alluded to this in his testimony in the amendment. First is the cost of expansion materials and labor to get to the number of customers available to receive service, and the question of whether there are enough reachable customers to make the expansion financially viable. And then the second is the expense and time it takes to complete surveys evaluating each pole's condition and the ability to handle additional cables, actually do the work preparing the pole for the new attachment. Again, that's known as make-ready work. And that's currently pretty time consuming and expensive. It's not uncommon that for engineering reasons, existing poles have to be replaced with a larger pole to accommodate additional attachments. So again, that's something that we're looking at in our new, in that new inquiry, and it was considered in the inquiry that led to the rule adopted just now. And finally, just I want to note that there should be, we're expecting significant federal assistance. The Federal Rural Digital Opportunity Fund, RDOF, recently awarded 4 companies $71 million for broadband expansion into unserved and underserved areas. And then the American Rescue Plan Act includes another $120 million for broadband expansion in Maine, in addition to the $50 million bond that was approved by Maine voters last year. So that's probably more than sufficient. Thanks so much for your time.
Thank you very much. Are there questions for the PUC from the committee? Representative Grochowski.
My first question is anyone as excited as I am that we're going to have a database of what's going on out there in the real world that hopefully will be spatially accurate? That was a rhetorical
Representative Grochowski, you're geeking out a little, which is very important for this committee because it's one of the qualifications for the committee.
Just, it feels like, you know, better late than never. That's all I have to say. I'm just curious, is the PUC looking at, or will it look at in this next phase, you know, that Georgia model that Representative Berry mentioned, or the rest of the concept of sharing the costs for what you said is the more expensive part of the make ready and surveying? And it sounds like maybe some of that surveying will go in the database, and then that of course would be sort of sharing the costs, I would think. So is the PUC going to directly look at that, or is it helpful for us to urge the PUC to look at that?
Absolutely. The short answer is yes. We are considering those things. I guess the longer answer is the committee is welcome to urge us as much as you see fit. So, you know, I don't think we'd see any harm in detailing, things the committee wishes for us to specifically tackle in any upcoming inquiries. And I think, you know, the Buck rule and other proposals, the question is, it's one of the policies that helps or could help, is proposed to help. And so the evaluation would be, you know, is this the best policy? Are there other policies that get at what we're trying to do? Things along those lines. So it's certainly in the mix of things being considered, but the committee would like to express, you know, with specificity and clarity, certain things that the committee wishes to see us look into. I think we'd welcome that.
Great. Any follow-up, Representative Grochowski? Okay, Representative Berry.
Thank you, Mr. Chair, and appreciate the forbearance since it is my bill. Mr. Corbin, I just wanted to follow up and try to understand that PUC proceeding a little bit more. So the historic approach has been, and it was referred to earlier by Mr. Sanborn, the cost causation model, where, you know, if I'm bringing broadband to an unserved area, then I need to pay all of the incremental new cost that's incurred, especially that make ready piece, being the subject of this bill. So does the PUC, are you saying that the PUC does feel that it has the authority as well as the intent to wipe the slate clean and not to assume cost causation principles, to in fact look at the sharing or socialization of these make ready costs, or not? Is that the PUC's intent, and do you have the authority to undo that historic cost causation principle, which requires unserved areas to shoulder all of the cost.
Thanks, Representative Barry. I'm not sure. I didn't mean to imply that we were going to do anything, contrary to kind of past precedent. I think this might be, if there is any confusion on what I said, it's probably a result of trying to respond simultaneously to the printed bill and the amendment. So I was, I wasn't aware if the amendment is still including those, cost, the socialization discussion that you proposed, and that I think you might be. I suspect you're correct that that would require some legislative direction to, I'm not sure that we would look into that proposal specifically on our own. So, but that's a great question for me to double check and respond in writing, if that helps.
That'd be great. Thanks.
Thanks.
Thank you very much. You all set, Representative Barry? Thank you. We do have the public advocate joining us again, so we'll go on to Barry Hobbins, who's going to testify neither for nor against.
Thank you very much, Senator Lawrence and Representative Barry and members of the Energy, Utilities, and Technology Committee. I'm Barry Hobbins. I'm the public advocate with the Office of the Public Advocate, and I'm here to testify neither for nor against LD 933. Now, let me say that I'm not going to go through my written testimony because it focused on the original bill and not on the revision, making it a resolve, which I believe is the right approach. The Public Advocate's Office believes that the best way forward to let the Public Utilities Commission continue their work in this area with strong suggestions, obviously, from the Committee of Jurisdiction. I think that's very, very important to have that lines of communications open. Our office would also like to suggest extending the deadline for the PUC report back to the committee, and that is scheduled for January 1st, 2022. And pick a date. I think it would be better to have that at the end of the next legislative session, and would be very, very helpful. And finally, the Public Utilities Commission needs to keep the lines of communications open, which they have, and I'm appreciative of that. And the Office of the Public Advocate does believe that there needs to be a more streamlined process and approach to addressing the expansion of broadband in our state, especially in the rural areas. A more comprehensive bill that incorporates all of the encompassing approach is really that involves the Connecticut Authority. The decision-making process, we believe, is the best way to achieve this ambitious project, instead of a number of bills that only address one or two issues and create inconsistency in the process. We found that Representative Foster does mention that some of the bills are inconsistent with what was passed during the last legislative session. So basically an omnibus approach dealing with not only the Public Utilities Commission, but the Connect Maine Authority, the Committee of Jurisdiction, legislators, is really needed if we're going to get the objection of the sponsor, Representative Barry, who I appreciate his willingness to take a leadership role in this area. So that's all I have to add. I would be more than happy to work with you. I'm really kind of excited myself that this LD could act as a vehicle for future discussion in a successful way. Thank you.
Thank you very much. Are there questions from the committee? Seeing none, thank you.
Thank you very much.
Jordan, we've completed the people testifying on this bill. Is that correct?
Correct.
Okay, then I'll declare the hearing on LD 933 to be closed. We are going to take our morning break now, and we will come back with LD 1107. So it's going to be a 15-minute break, and we will be back. We'll make it right at 11 o'clock. So please turn off your videos and mute yourself. How we doing on numbers? It's like 1, 2, 3, 4, 5. One, 2, 3, 4, 5, 6, 7, 8. Looks like we're good to go. Okay. We are going to start back up with LD 1107, an act to create needed broadband infrastructure in rural Maine through the establishment of a satellite-based broadband grant program. Chair is pleased to recognize the sponsor of the bill, our very own Senator Trey Stewart.
Thank you very much, Mr. Chair. Good to see you all and be with you this morning. Senator Lawrence, Representative Barry, and my colleagues on the Energy, Utilities, and Technology Committee. I'm State Senator Trey Stewart, and I have the distinction of representing 51 communities in Aroostook and Penobscot counties. I am before you today to present LD 1107, an act to create needed broadband infrastructure in rural Maine through an establishment of a satellite-based broadband grant program. It's a long title. As you have all seen play out over the past month or so, there's an interest among myself and my colleagues in working with satellite internet providers to address the last mile issue facing Maine in broadband access. Ideally, this bill would have come out in advance of the budgeting process that this committee undertook, and the voice of minority Republicans would have been more seriously considered as a part of that biennial budget. Given that both of these things didn't occur, we are now having to have this discussion after the fact today, though that doesn't mean it's any less a significant conversation to have. To be sure, minority Republicans represent rural areas of the state. You hear this when I introduce myself at the beginning of each hearing, as well as my colleagues. As stated before, I have 51 communities in northern Maine, geographically 50 times larger than the House district I previously represented, and one of only 2 populous areas in my district. This does not mean, however, that the people who don't live in larger towns or along busy traffic corridors matter any less or should be any less of a priority for connectivity. In fact, I would argue just the opposite. We should be doing all that we can to ensure that our rural counterparts have the same opportunities to live and work in rural Maine, not just in the urban parts of our state. In my opinion, population shortage in the rural parts of our state is the single greatest threat to the residents there, as it makes everything about living there more challenging and has a spiraling impact on life there. As such, we put forward this measure this year. This bill explores the idea of doing all that we can to reduce barriers to connectivity and do so in a way that's affordable and makes sense financially. As you'll see from this bill and recall from our previous conversations around this issue during the budget, there are technologies that are developing in the world of satellite internet that are worth exploring. If you live down the end of a long road in rural Maine and are presently unserved or underserved, it would cost the utility roughly $20,000 per mile to connect that home directly with fiber. This amount does not include the monthly payments owed to the company after that connectivity. This bill proposes a different route. By providing for the initial upfront costs of satellite infrastructure, really synonymous with what the state is paying for infrastructure costs to hardline cables and poles around the state, we can make great strides to serve these people. While it costs tens of thousands of dollars to connect remote Mainers with fiber, it costs hundreds to utilize other methods to ensure the same level of connectivity. As the bill states, a $500 reimbursement for the satellite infrastructure will allow these individuals who are truly unserved and underserved, who are at the lowest priority for connectivity with Connect Maine and others, have a chance to be treated fairly. Obviously, and as came out in our previous discussion around this issue, Starlink is one such example of a company that would make sense to experiment with this initiative. With a small investment relative to the amount provided to other carriers, we could see literally thousands of Maine people connected with high-speed internet. We are particularly well suited for this venture, given the geographic rollout of this company's efforts with regard to the satellite launches and onlining efforts, meaning that we as a state should be working particularly hard to ensure that those Maine citizens who need a service that they offer are able to access it with the same level of commitment as we provide other users of the internet. To be sure, this bill and this effort and attention is about a certain degree of parity. We aren't saying that one is better than the other, just that we should be utilizing every tool in the toolbox and not precluding Maine people who will be excluded because of one algorithm or another. I hope that we can build a broad team, one that includes every provider possible in some meaningful way. I also want to be clear that this initiative in this legislation in no way is meant to circumvent the critical investments in fiber that need to be made across Maine. I recognize the need to make these investments, and I hope to broaden the reach of broadband access in Maine through a variety of technologies. However, where it makes sense to utilize these options with a level of state support that is small relative to other investments in the same space, but effective with regard to connectivity, we can accomplish both goals. There needs to be a balance struck with regard to the cost to connection ratio, and that's what this bill seeks to do. I appreciate this committee's time and consideration of this important legislation and look forward to answering any questions that you have at this time. Thank you, Mr. Chair.
Thank you very much, Senator Stewart. Are there any questions from the committee? Representative Foster.
Thank you, Mr. Chair, and thank you, Senator, for your presentation of this bill today. It's been mentioned earlier in how we can best serve rural communities and helping with some of the costs involved for connectivity. And I believe it was the public advocate who mentioned possibly an omnibus type approach to all of the costs involved and all of the opportunities involved. Would you suggest through this bill that we look at that last person down the line as having a less expensive option available through your bill than possibly we might find if we went to the expense of running cable to their house that could be supported by other ratepayers or citizens of the state of Maine? Is that how I'm to understand this bill?
Thank you for the question, Representative. And yes, from a high level, that is essentially what we're seeking to do. We're not saying that looking at other options like fiber, it don't make sense. I'm not suggesting that at all. What I am suggesting is that if you are to try to run fiber to every home in the state, it's going to take, first of all, a long time, and second of all, a large amount of money. This alternative option, and others like it too, this is not to suggest that, I'm solely in favor of satellite for everybody. I think where it makes sense, the state should be stepping up its role with regard to how those connections are made. I see it all the time. In fact, we heard about it just this morning, right? Tens of millions of dollars, hundreds of millions of dollars going to other initiatives that have a lower ratio in terms of money connections made. Whereas if an alternative option makes sense to get somebody connected now and do so at a much more affordable rate, it makes sense to bake those calculations into what the plan is for the state going forward. And in my opinion, and what I've seen in my 5 years in the legislature, that's largely been boxed out by other efforts to make those hardline connections. And I think that we have an opportunity here and now to do something different that should be explored.
Representative Foster, any follow-up?
No, thank you.
Okay, any other questions from members of the committee? I have lost my Zoom screen momentarily, so just shout out and I will recognize you. There, I'm back. Seeing none, thank you very much, Senator Stewart. We're on to those people speaking in favor of this legislation, and there are none, so I will go to those speaking against the legislation. And I recognize, first of all, Andrew Butcher from Portland. Andrew?
Greetings, Senator Lawrence and Representative Barry, members of the Energy and Utilities and Technology Committee. My name is Andrew Butcher, and I'm here on behalf of the Maine Broadband Coalition, your partner in creating solutions for broadband policy and programming, to testify in opposition to LD 1107. The Maine Broadband Coalition is a statewide network of over 2,200 stakeholders working to advance the policy, resources, and infrastructure necessary to enable affordable, reliable, future-oriented, high-speed internet for all. The coalition is guided through a 30-member advisory committee representing a range of geographies, industries, sectors, and issues, as high-speed internet is foundational to our collective economic, social, and environmental prosperity more than ever. Innovations and new technologies, combined with the essential foundation of a robust fiber network, merit our consideration and adoption. But LD 1107 misses the mark and potentially sets a dangerous precedent. Legacy satellite-based internet providers often don't provide service that qualifies as broadband as defined by the Federal Communications Commission, 25 megabytes down by 3 megabytes up, and should not qualify for state subsidy. New offerings for satellite-based internet, such as Starlink, are only in beta testing mode with many critical questions unanswered, including, will there be enough capacity on the network once more people sign on, or will service diminish? If there's an incentive for consumer use, what is the need for fiber backhaul? What are the environmental impacts of a tenfold increase in satellites in Maine's night sky? Will standards be put in place to ensure safe and effective installation of subsidized services? If so, who's to be responsible for the development and oversight of such standards? As a recipient of the FCC's Rural Digital Opportunity Fund, RDOF, it's also unclear whether Starlink qualifies for any state subsidy. It's also unclear if the proposed subsidy will be means tested to support the people in most need and how that will be administered. Lastly, it's unclear how the proposed subsidy would be in place long-term, a critical factor given the annual costs associated with satellite service. So as a diverse coalition ranging from the Central Heuristic Chamber of Commerce to AARP to the Maine Farmland Trust, we know the intent of this bill is to help provide immediate relief to disconnected residents, and we invite Senator Stewart to strategize with the Maine Broadband Caucus, which the coalition is helping facilitate on behalf of this body, so that sensible and practical solutions can be found towards common ground. Fortunately, the next meeting for the caucus is tomorrow, April 7th at 6 p.m. Details are at the mainbroadbandcoalition.org, including maps of which districts have been present and participatory in the caucus, and we welcome all of the sponsors of this bill to attend. As many of you know, there's not a magic wand to address the challenges of connecting people in remote places. The proposed solution here will only perpetuate a digital divide in Maine, not alleviate it. Thank you so much for your time. I look forward to any discussion.
Thank you very much. Are there questions from the committee for Mr. Butcher? Representative Foster.
Thank you, Mr. Chair. Thank you, Mr. Butcher, for your testimony. Question I have, as we looked at, and I'm relatively new here, joining the legislature in the 129th, but as you recall, a lot of the broadband discussion and how we can expand that really heated up during the 129th. And a lot has been brought up about businesses and such that can be expanded or brought to Maine. My question is one that I've asked many times, and of your coalition, certainly it's something you may be able to answer from you or those you represent. And that is, as we look at more and more dollars coming from ratepayers, taxpayers to help with this effort, question still remains, what is the last mile expense that is too much? And with that question hanging in the air still, I'm wondering why this might not be a good opportunity for businesses, especially in very rural parts of the state, northern Maine, why this might not be a solution for them in the meantime, especially those such as sporting camps or those who may want to start up something of that capacity, who would have to drive several miles just to access cell phone access, and certainly are beyond even that, what might be a very high expense to get that last mile. So I'm wondering why you wouldn't consider that, trying, even if some might say it's a pilot program, something along this line might not be helpful as we look at some of those residents in the state and some of those businesses. Thank you.
Go ahead.
May I respond?
Yes, go ahead.
Oh, thank you. Well, thank you, Representative Foster. If I understand your question correctly, allow me to also just clarify. My testimony today is not against the trial and or use of such technology to support the most disconnected residents by any means. I think we as a coalition embrace, as Senator Stewart so well put it, all tools in the toolbox. I think the commentary this morning is that this isn't necessarily the best way to achieve that. And there remain to be a number of questions to address before we consider ratepayer subsidies towards specific technologies and technology providers.
Any follow-up, Representative Foster?
No, thank you.
Okay. And we didn't, I don't believe Representative Carlo was here this morning when we did introductions, so I'll ask him to introduce himself, and I believe he may also have a question.
Thank you, Mr. Chairman. I'm Representative Nathan Carlo. You'll have to excuse me. I have a little bit of a cold, so if my voice sounds stuffy, that would be the reason. I'm proud to represent House District 16, which is part of Buxton, Olive Hollis, and a part of Saco. And I do have a question for Andrew, if I may proceed, Mr. Chairman.
Yes, go ahead.
I guess I'd just like to know, and forgive me, I'm new to this committee, so when I claim ignorance, I think that's a very valid argument. I represent a rural area, which is why I co-sponsored this bill, and I think that if Starlink or another satellite program similar to that is the only option available to people who don't have access to broadband, what would be the harm in proceeding with this pilot project? I'm not understanding why that seems to be so controversial. Thank you.
Thank you, Representative Carlo. I appreciate it. And thank you for your willingness to share your exposure to the new industry. I think it's shared among many. This is a complicated issue for all. But to clarify your question, when you say opposition to the pilot, the intent of the bill as written was to provide subsidy for use of the technology. So my response today was not in opposition to the use of the technology, but in essence of the subsidy as currently worded. I think there are, we as a coalition have no concerns about the use of any technology to be able to provide connectivity for the most remote residents. But as worded in this legislation, none of the questions that I emphasize are addressed, and we as a coalition would like to see those types of issues addressed and developed in collaboration with the Broadband Caucus.
Representative Carlo, any follow-up?
No follow-up. Thank you.
Okay. Other questions for Mr. Butcher from the committee? Okay, we'll now continue with people testifying against the bill, and I'll go to Benjamin Sanborn of the Telecommunications Association of Maine. Benjamin?
Thank you, Senator Lawrence, Representative Berry, members of the committee. My name is Ben Sanborn. I am Executive Director and Counsel for Telecommunications Association of Maine. We are testifying in opposition to this bill really just for two reasons. One, it's focused on a single technology, and really the history of what has driven the internet growth and innovation has been a technology neutral approach, that making sure that you don't inhibit how the market proceeds has been really essential to the growth and expansion of broadband and internet, to a point where it's now something that is being discussed as a potential utility. And so we don't believe it's appropriate to limit things on a technology basis. The second reason is that the bill does not appear to have a limitation with regard to low-income individuals. It's our belief that if you're going to be using public dollars to support the use or purchase of service, it should be for low-income individuals, that the public dollars are limited and should be limited. But there are good times to use them, and those times are when it's to make a service affordable for those who otherwise would not be able to afford it. And so with that said, I think that the principle behind this legislation is very good and important, and one we need to start thinking more seriously about. And that is affordability, and how to use state resources to really promote affordability. We're getting a lot of federal dollars now for infrastructure growth. There is the state bond for infrastructure growth. I think that with all the initiatives that are happening currently and at the federal level for infrastructure build out, I think it's a good time for the state to really start thinking about how do we address affordability, and how do we get to that issue where, rather than picking a technology, we say, okay, if this is the service that's available to you, what is the cost? What is your need? Is there a way to make that affordable to you? Whether it's because you're in a remote area of Aroostook County, or because you're a student in a rural area and you can't get you can't afford the connectivity that runs past your house to connect to your school. And so we think it's a broader question, but we think it's an important question that we need to take up now. And so with that said, I know there's been discussion about omnibus legislation and how to really address the core issues here. I think it might be a good time to start thinking about that and really roll these concepts into the idea of how do we make sure that everyone has affordable access, whatever the technology. That if that means give a link up. In the old terminology, there used to be Lifeline and Link Up. Lifeline was your low-income monthly cost, and Link Up was the cost for low-income people to connect to the service, which is essentially what this bill is talking about. So if you have some sort of broadband link-up cost, that would make sense on a technology neutral basis. So I think these are important discussions, and hopefully we will continue to have these discussions for how the state of Maine can pivot towards an affordability issue. With that, I'm happy to take any questions.
Are there questions from the committee? Seeing none, thank you very much.
Thank you.
We will go on to Peggy Schaefer from the Department of Economic and Community Development, who will be testifying against this legislation. Peggy?
Hi, my name is Peggy Schaefer. I live in Vassalboro, and I am the director of the Connect Maine Authority. We are testifying in opposition, and I think some of the testimony before me has brought up sort of the key reasons why. One is the limitation to a specific technology. The satellite service currently does not meet our definition of broadband service, and the low Earth satellites are still in the beta test. They're not really ready for commercial development. They're not really commercially available yet. There's a waiting list of well over 10,000 people globally to get online. So, and they are testing and adjusting. So they're picking who they, based on where they need to test this stuff out, where their service goes. The issues around there's no income eligibility here, so you can figure that out. The question about businesses, this legislation does not allow businesses to access this technology. So I think there's some problems with it. With that said, we have in the past year tried to figure out how to do these sort of line extensions or last mile or the customers, right? So there's one Vermont last year used CARES money to provide funding per home to connect to a service. They're the only state so far that's done that. We this year changed our grant processes. So we have a community grant, which looks for more universal service, and then what we're calling a line extension grant, which can help for 10 or so customers who just need a line extension to get connected. So we recognize this as a problem, and we have begun to address some of it. So it's not that we're opposed to this idea. We think funding one technology is sort of a mistake. It's also obviously not in the governor's budget. But I will say that we are looking at this kind of strategy. We have a triennial plan we're coming into this year, and there are many things that we're looking at as part of that. Some of it is trying to figure out how to encourage more towns to get together to build bigger projects, right? So that we can do more building of these networks and more regionalization. Some of it is how to do these sort of last mile pieces. All that, just to say that I think this is maybe a little premature for this kind of activity. I think there needs to be a lot of other pieces looked at, including affordability around this technology, making sure that there's a method for doing this kind of rebate for essentially a connection for more than one technology, and a prioritization for unserved versus served. And the final thing I will say is that it is unclear whether it is not unclear if our Starlink in particular and Viasat in particular both got funding through the FCC to expand service in Maine. And with the RDOF money, you cannot get other state subsidies to expand that service. And so there's 14,000 locations in Maine that are in the RDOF area that would not be eligible for this subsidy. And those are probably the most rural, right? They are the most rural part, and they would not be eligible for this subsidy because, and so that I think is a consideration as you move forward here, is to figure out what you're going to say to those 14,000 locations that are in the Starlink RDOF bid, but could not be eligible for this subsidy. So that's it.
Are there any questions from the committee for Ms. Schaefer? Representative Foster.
Thank you, Mr. Chair, and thank you, Ms. Schaefer, for your testimony. I have one question, as you mentioned it and others have as well, that this bill would be subsidizing one form of technology, and we shouldn't go there. But aren't we, in fact, through Connect Maine or even private enterprises now funding or helping to fund one technology, that being fiber cable, and that's our technology for distributing broadband in the state of Maine?
So we have a build standard of 1010, which coax cable does meet. So it is, and also wireless technology does meet. So we are not funding just fiber. We are funding a connection that can give you a 10 up and a 10 down, which does, like I said, include wireless, and it does include coax.
A follow-up, Representative Foster? Okay. Other questions for Ms. Schaefer from the committee? Seeing none, thank you very much. We'll now go on to, excuse me, individuals testifying neither for nor against this legislation. I'll recognize the public advocate, Barry Hobbins. Barry? We're having a little trouble with your audio.
There, that should be better.
Good, great, thank you.
As I mentioned, my name is Barry Hobbins, and I'm public advocate with the Office of the Public Advocate, and I'm here today to testify neither for nor against LD 1107. The Office of the Public Advocate understands it is imperative to expand internet access to rural Maine, in the rural areas of all of Maine. However, a $1 million appropriation to fund grants related specifically to satellite-based internet providers is really a tough sell coming off a very difficult year when state funds are already stretched to the limit, especially when these companies are already being substantially funded by federal grants. Additionally, the OPA is unsure that the Public Utilities Commission has the means to process these applications and distribute funds to individuals. Another potential drawback to this proposed legislation is the cost of the service. According to a recent piece by the Wall Street Journal, which I've referenced and linked to my testimony, they explained in the piece that beta testers for Starlink, one of the star satellite-based internet providers based in rural Washington State, not only required $500 for the equipment necessary to utilize the service, but a monthly cost of almost $100 for the service itself. It is our understanding that the grant program proposed in this bill would help with these costs, but our office is not convinced that this service will be accessible for the majority of low-income Mainers in rural areas who are searching for a solution to their problems assessing affordable and reliable internet. The OPA is unclear if the funds could be applied to monthly leasing fees for satellite providers who spread the cost over the life of the contract rather than the upfront charge. The OPA believes that the title of the bill is somewhat misleading because there is no infrastructure being funded by these grants. The equipment would be privately owned, and the bill explicitly states that, quote, the grants awarded only to individuals applying for on behalf of a residential household, and that grants may not be awarded to business entities. It is unlikely that this bill would result in a large-scale internet access for communities. Instead, it only applies to the services of citizens who can afford this service. This bill essentially subsidizes one type of internet over others, even if there are other services and technology available at the home. This is important to provide an educational component to inform consumer choice rather than shape that choice for the consumer. Finally, the Office of the Public Advocate believes that there needs to be a more streamlined approach in addressing the expansion of broadband in our state, especially in rural areas. And as I mentioned earlier in my testimony in another bill, a more comprehensive bill that incorporates all encompassing ideas and approaches will be the best way to achieve this ambitious project instead of a number of bills that only address one or two issues. We urge this committee to look carefully at this bill because of the fact that rural Maine and those low-income people in Maine will not be serviced by this type of approach, just because of the cost factors involved for the upfront cost and the ongoing $100 per month cost. If you have any questions, I'd be more than happy to answer them. I commend the sponsor, Senator Stewart. He is a dedicated advocate for Aroostook County in the northern part of Penobscot County, and I'm glad that he's taken up this cause, and this is just one tool in the toolkit. But I know he knows that, and he'll work zealously for the citizens of his district. Thank you.
Thank you very much, Barry. Are there questions for the public advocate from the committee? Seeing none, thank you.
Thank you.
Jordan, do we have anybody else to testify on this bill?
That looks like it's it for 1107.
Great. So just to give you everyone an idea of the schedule, I'll first of all declare the hearing on this bill closed. Just to give you an idea of the schedule, we have 2 bills left. It looks like LD 920 has about 20 people to testify on it. So I'm expecting that will last at least an hour. And the last bill we will be doing, which is LD 815, has about 7 people to testify. So I'm expecting that will be about half an hour. So with the committee's consent, I would like to go straight through these bills, not break for lunch at 12:30, but go straight through these bills and finish up our hearings this morning. And unless I hear any major objections, we're gonna proceed with that plan. Okay, I don't see any major objections, so we'll go on to LD 920. An act to promote oversight and competitive parity among video service providers. And the chair is pleased to recognize the sponsor, our very own Representative Kessler.
Thank you very much, Mr. Chair. Is everybody able to hear me okay?
We can hear you fine.
Okay, great. I will try to keep this brief. I am pleased to be introducing this bill today. This is a result of the stakeholder meetings that occurred over the summer and early fall that was looking at the creation of a statewide franchise agreement. This bill has been introduced really on behalf of the Community Television Association of Maine. And I would encourage committee members, if you have detailed questions about the bill itself, that some of the folks from CTAM would be best equipped to answer those detailed questions. There was an amendment that was sent to everybody this morning that is not a substantial change, but it has to do with just how the PUC would be able to get resources to pay for oversight of the telecoms. So really, this is introduced because more Mainers watch live TV over the internet as opposed to cable and satellite. And it's meant to have parity in both cable and telecom in terms of paying for access to public television. So those who deliver TV over the internet service are not sharing in any of the obligations, financial or otherwise, that's associated with providing that public service. And so this would require those IPTV operators to obtain individual franchise agreements with municipalities. And it would bring both IPTV operators and cable providers under the regulatory and licensing umbrella of the PUC. And it formalizes the notion that they are, in essence, public utilities. Once again, the amendment that was presented deals with how the PUC pays for oversight. It also, the bill ensures that fiber used to transmit public meetings get upgraded and that cable operators don't pass that cost of that upgrade on to the municipality. And we have to remember, as we consider legislation of this nature, that when it comes to cable and internet providers, we're talking about commercial use of public rights of way. And the cable companies may come, or the cable may come from the providers, but the roads along which they run are very much public. And it stands to reason that the people of Maine who pay for those roads are entitled to at least the modest public-private collaboration that goes into providing public access channels. So I'll wrap up my testimony. And I will do my best to answer any questions that you may have. But once again, I would reserve those for those who have more history in the industry.
Thank you very much, Representative Kessler. Are there questions from the committee? Seeing none, thank you very much. We'll go on to co-sponsors on this bill, and I believe we have Senator Keim here to join us today. Senator?
Good morning, and just to clarify, I am not a co-sponsor, but just joined in to offer testimony because I am interested in public access television and wanted to offer support from that perspective. So good morning, Senator Lawrence, Representative Berry, and members of the Joint Standing Committee on Energy, Utilities, and Technology. I am Lisa Keim, and I'm proud to represent the citizens of Senate District 18, which includes Northern Oscar County and 2 communities in Androscoggin. I'm here today to speak in favor of LD 920, an act to promote oversight of and competitive parity among video service providers. I understand this legislation stems from meetings held last summer and fall with representatives of the Community Television Association of Maine, current cable television operators, video entertainment service providers, Maine Municipal, the PUC, Connect Me, and Office of the Public Advocate. It became clear in their meetings that the new entrants in the video entertainments to the home business were only interested in selling their cable TV-like entertainment products over their lines using the public right-of-way. In doing so, they were not entering into municipal contracts, and this is unlike traditional cable TV operators who hold individual franchise agreements with towns. LD 920 aims to address this issue. I leave to others to speak on the intricacies of this legislation and for the committee to find balance between the objectives. As I understand, there may be concerns on impact to costs and complications with the contracts. But the reason I'm here is speaking is to share what I believe is the overall imperative in supporting public access television and the importance that funds from the use of public ways be used to benefit the community, giving them access to producing their own media on local access TV. Public access to the airwaves, I believe, is becoming more crucial. Big tech and news media only offer information that is sensational and sells. They also have an accepted narrative that disallows divergent and diverse viewpoints equal access. Public access is an electronic soapbox that allows free expression and can protect our First Amendment rights. The origination of public access offered people of the community the ability to express themselves. And in these days of the World Wide Web, where misinformation is difficult to decipher, people are more than ever seeking truth, not just sound bites. There's a crying need for substantive, political, public affairs programming that comes from a local place and from people within our communities who are accountable because they are one of us and we know them as real people. In closing, public access television is a free speech platform. And along with equitable funding, there should be laws that protect it as such. Free speech is the very bedrock and foundation of maintaining our democracy and the freedom of our citizens. I thank you all for your consideration of this bill and the work I know that you'll put into it.
Thank you very much. Are there questions for Senator Keim? Seeing none, thank you.
Thank you.
We'll now go on to another senator testifying in favor of this bill, Senator Rafferty. And welcome to the committee, Senator. We'll give you a second to unmute.
Thank you very much. This transitioning is challenging as well, but I appreciate the opportunity to speak with you folks this morning. My name, Senator Lawrence and Representative Berry, distinguished members of the Energy, Utilities, and Technology Committee. I am Joe Rafferty, and I am the Senate. I represent Senate District 34. And I am here this morning to speak with you folks on behalf of those constituents in that area. This bill was first brought to my attention when the folks at the Berwick Community Television reached out to me a few weeks ago asking for my support. Since that time, I've been working with them to understand their position as a small municipal broadcasting network and how this bill would actually affect them. I'm sure you'll hear testimony from them this morning, but I would like to share what I've learned. When they first approached me, they had several reasons for supporting the bill, but the two stories in particular that spoke volumes about the necessity for passing this bill, I'll share. First, Berwick Community Television said that they have requested information from Comcast for the last 2 years that they had not received. These included records of complaints, outages, service calls, a map of our coverage area, total number of subscribers, total miles of new cable installed, total revenue, and other information the franchise may include. Municipalities and public access stations should not have to hire a lawyer or to go to court for something their contract specifically states that they have the right to know and request. The bill requires cable operators to be licensed and regulated by the Public Utilities Commission, which Berwick Community Television tells me would help solve their problem. Secondly, it came to my attention that the video service providers like Comcast have been compressing high definition videos edited and produced by small municipal television stations like Berwick Community Television into standard definition, despite having the technology to transmit the video in high def. This bill increases the franchise fees to 5% statewide as of January 1st, 2022. This will be paid quarterly to the towns, and it also requires the video service providers to own and pay for upgrades like high definition transmission to the fiber transmitters that they own instead of passing that cost on to municipalities. These are just a few of the reasons why I'm supporting the passage of LD 920. The bill looks out for the municipal access stations and promotes parity between them and bigger companies like Comcast, as the title of this bill suggests. Fighting for the local companies and parity among video service providers is certainly the right thing to do. I thank you for your time. I'll do my best to answer any questions you may have, but kindly ask that you reserve some of the more technical questions for folks who will be coming in to speak behind me from Berwick Community Television. Thank you.
Thank you very much, Senator. Are there questions from the committee for Senator Rafferty? Seeing none, thank you very much.
Thank you, sir.
We will continue with proponents of this bill. And we'll go on to John Gorin from Freeport. John? I think you just have to unmute yourself, John.
Yes, good morning, and thank you, Mr. Chair. I appreciate your time, everybody. Senator Lawrence, Representative Berry, and members of the committee. Sorry about that, on energy utilities.
We rate people's ringtones in the hearing.
Yeah. I will shut this thing up so it won't do that again.
Okay.
There we go. Let me start again. Thank you for your indulgence. Senator Lawrence, Representative Berry, and members of the Committee on Energy, Utilities, and Technology. I am John Gorin of Freeport, and I am pleased to support LD 920, an act to promote oversight of and competitive parity among video service providers. I am a member of the group of folks who work with municipalities every day, who are the primary contributors and researchers of LD 920. My background is as a licensed and certified telecommunications engineer with over 40 years in the broadcast and audio video industries and over 20 years in municipal service here in Maine operating, and managing public educational and governmental access television facilities. Our group is proud of the extensive research involved in this proposed legislation. Information and legislation from many states, organizations, companies, many interviews with individuals, and more has been gathered, compiled, reviewed, and considered by our group. Many meetings have been held and attended. Each of us has put in countless hours on this project. The result of our research and deliberations is LD 920. We believe this legislation is in the best interest of all the people in the state of Maine, as well as our municipalities. Governor Mills recently called the media giants' use of the public rights of way for commercial purposes, quote, as fundamental as electricity, heat, and water, end quote, and the, quote, modern equivalent of rural electrification in the 1930s and the interstate highway system in the 1950s, end quote. The legislation we are proposing fits right into the governor's viewpoint by promoting oversight of and competitive parity among video service providers. Adding to the list of public utilities has been done in a number of states and has been a part of legislation in others for some time. We submit it's time to add that list here in Maine. I ask for your support for LD 920 and its amendments. Thank you.
Thank you very much. Are there questions from the committee? Seeing none, thank you.
Thank you.
Okay, we'll go on to our next individual testifying in favor of this legislation. And it is Terry Wright from the Berwick Community TV. Terry?
Good morning. I don't see myself, but I hope you can hear me. Can you?
We can hear you fine, Terry.
Perfect. All right. Senator Lawrence, Senator Berry, and members of the EUT committee. My name is Terry Wright, and I am the director of Berwick Community TV. I am also the newly elected chair of the Community Television Association of Maine. If passed, I believe this bill will help municipalities and residents. Along with broadband expansion, public access stations offer an opportunity to inform and educate residents via government meetings and public service announcements. Housebound residents will be able to see their local parades and events, school concerts, and special speakers. This is all made possible by requiring IPTV operators to obtain individual franchise agreements with each town. It is further made possible by standardizing the 5% franchise fee and having that fee returned to the towns on a quarterly basis. As we all know, cable giants like Comcast and Charter have plenty of money. Rather than simply complying with many of the contractual pieces of an agreement, they can sit it out, forcing municipalities to either give up or spend money to have their attorney send a legal notice. Of course, cable companies can still ignore the legal notice, and most times with confidence that the municipality will give up rather than go to court. This is why the addition of LD 920 that requires video service providers to be licensed and regulated by the PUC is such a large piece of this legislation. These requirements make it a more level field for the municipalities. The primary purpose of this oversight of the PUC is to assist municipalities with non-compliance issues that often require technical, financial, and legal resources. Litigation is costly, and as previously noted, one side has plenty of money to litigate while the other does not. LD 920 will require cable providers to own and pay for upgrades like HD to their fiber transmitters and equipment. In Public Law, Chapter 245, Section 5B of an Act to ensure non-discriminatory treatment of public educational and governmental access channels by the cable operators, this includes a phrase that states, a cable system operator shall carry each public educational or governmental access channel in both high definition format and standard digital format in the same manner as that in which their local broadcast channels are provided, unless prohibited by federal law. We know that is not the case. Of course, cable providers found the loophole. Since no fees were discussed, someone in the industry determined a change for this service must be assessed. Interestingly, when BCTV upgraded to add a second channel, our cable provider, Comcast, also upgraded their encoder in our office. This encoder will take and send both SD and HD channels. It was installed more than a year ago, and when we last met with Comcast, I was told in order to go to HD, I needed to pay them $5,000 for the piece of equipment that sits in my office now. Of course, they did offer to add on to the contract and stretch it out over 13 remaining years. However, they also said that I can only have one channel to upgrade to, and that channel couldn't stay at channel 22. It would have to go up into the much higher digits because that's where their HD channels are located. So first they find the loophole, then they raise the bar so high that many municipalities like ours have very few options. It's time to hold these companies accountable. It's time to level the field for all players. Please pass this piece of legislation on and create opportunities for municipalities all over our state. Thank you very much.
Thank you very much, Terry. Are there questions from the committee? Seeing none, thank you. We will go on to our next proponent, who is Tony Vigue of the Community Television Association of Maine.
Thank you very much. Senator Lawrence, Representative Berry, and members of the committee, thank you for allowing me to testify in support of LD 920. My name is Tony Vigue, and in the interest of brevity, please refer to my written testimony for the reasons behind the creation of this bill. Many specific examples are available upon request. For the past 35 years, I've worked in community television, mostly volunteering with Maine nonprofit organizations. I was also the manager of South Portland Community Television for 21 years. And in these capacities, I've had a front row seat in the municipal cable franchising process. I've assisted dozens of towns with cable franchise renewals, mostly for free, but some on an expense fee basis. Municipal officials and volunteer committees renegotiate franchises every 10 or 15 years, unlike cable attorneys who do this every day. Towns are understandably naive about cable law and franchises so that they don't recognize the harmful, subtle language that deprives them of protections and benefits allowed by law. For example, prohibiting municipal cable ordinances from having any effect on the operations of the provider in the community is wording that's commonly found in their corporate franchises. Another apparent example is being told by the cable operator that they must choose between requiring a franchise fee or requiring capital grant for audiovisual equipment, when the town could legally do both. I would urge the committee to pay particular attention to the PUC testimony, which you're going to hear, which outlines the plethora of responsibilities that are required to effectively regulate the operations of video service providers in the community. And ask yourselves, how effective do you think municipal employees are in carrying out those responsibilities? They're pretty detailed. With this bill, the towns are not giving up any local control. They're gaining additional resources. The pennies per subscriber that it will take to fund this will be a small percentage of the annual rate increases that are imposed on customers anyway. Some municipalities may see a small decrease in the franchise fee owing to the federal law that permits the regulatory fee to be deducted from the franchise fee in certain cases. However, the increase from new IPTV providers that are required to have a franchise by this bill, plus the universal 5% franchise fee, should exceed any regulatory fee deduction from the franchise fee. We all recognize that video and internet services travel over the same facilities along the public right-of-way. State-level oversight of this infrastructure is essential to ensure compliance with state and federal laws governing all of these services, as we've seen in recent months. The current whack-a-mole approach by towns is not productive, and a state-level solution is necessary. Legal guidance in franchise renewals and non-compliance issues from an authoritative state-level resource is provided by LD 920. Further documentation to support these facts is available upon request. We don't have to look any farther than the state of Texas as an example of what happens when you have light regulation or no regulation of essential services. I urge you to support LD 920 now, so we don't have to revisit this again in the future when towns are at a greater disadvantage than they are already. Finally, I would also like to say that without the professional assistance and extreme patience exhibited by the Office of the Reviser and the OPLA, this complex legislation would not have been possible to bring forward to you. Their efforts on behalf of Maine citizens working behind the scenes go largely unnoticed most of the time, and I'd like to thank them for their expertise and diligence. Any questions I'd be happy to take from the committee.
Thank you. Are there questions from the committee? Yes, Representative Stewart. Excuse me, Senator Stewart.
Thank you, Mr. Chair. I appreciate it. Thanks for your testimony, Mr. Vigu. So I'm actually taking utility law this semester, and the definition of what a utility is kind of an interesting thing. It's essentially whatever the legislature says it is. But that said, it typically involves things that are fundamentally necessary for many aspects of human life. Things like running water, electricity. It can be as obscure though as a ferry service, because if you live on an island, that might be necessary for life there. I fail to recognize though what is necessary about a luxury service like television, and specifically public access television, when it is accessible in other means that don't involve passing along a fee to everyone in the state of Maine on top of what they already have to pay. And so I'm hoping that you can shed some light onto what exactly is necessary about moving forward with this idea of a franchise fee being added to everybody's bill for a service that is essentially redundant. And I hope that you're the right person to ask that question to. Maybe you're not. I've sat here and tried to formulate my thoughts over the last few speakers, and unfortunately you're the guy that I'm fielding this question to first. So I'll let you take a whack at it. Thank you.
Thank you very much for that question. It's a good question for those who haven't been living in this for 30 years. I think there's some seniors in retirement communities who might give you an argument as to the how essential cable television is, but let's put that aside for the time being. The idea is that this is a entertainment service that uses the public right-of-way. And under federal law, municipalities are allowed to charge a rental fee for the use of the public right-of-way. And that rental fee is called a franchise fee. And it can be up to 5% of the operators or the providers' gross revenues. And there's a very specific definition in federal law for that. So towns may charge this rental fee for the use of their public right-of-way, just the same as you would charge a commercial entity a fee for using the public park, because it might be the dusty side of the road where the cable lines go, but under the law, it's a public right-of-way and is treated the same as a public space in a public park. So the town is allowed to get compensation for the use of that public space for commercial purposes. And so that's the basis behind a franchise fee in a nutshell. And so a lot of towns, when they enter negotiations with the cable operator, will hear from the cable operator, you don't want to charge this fee, because you'll have citizens down here complaining that you're raising their rates. When in fact, the cable companies are going to charge what the market will bear, because they're business people and that's what they do. Regardless of any fee that the town may impose or that the state may impose, the cable operator is going to charge what the market will bear. So this fee actually deprives the cable operators of charging that little extra amount, the amount of the fee that they could have charged. And that's why they object to it. And in our opinion, the town captures that money locally instead of letting it go to the cable operator, as do millions and millions of dollars every year, and use that fee to give the people in the community back something for that little charge, that rental fee that the cable operators have chosen to pass through to their subscribers, by the way. They don't have to, but they've chosen to do that. It gives the viewers something back for that little fee on their bill. And that is better communications with their town government through the public education governmental access channels, or in some cases, the selectmen will choose just to offset the tax rolls, by using this fee as additional income. We hate to see that. We like to see the fee going to provide some community benefit in the form of better communications with their town officials, open government, and that sort of thing. But that's the history behind the franchise fee and why it's on the bill. Some towns get 2 or 3%, and they only get annually. The cable companies keep the fee all year long, collect interest on it, and give it to the towns annually. But this bill requires all towns to receive that money quarterly and at the full 5%, because the cable companies are going to charge what the market will bear. I hope that answers your question.
Any follow-up, Senator?
Well, I mean, it still, I don't think it's gotten at, I mean, I feel like at the end of the day, we're going to go around and around and have a philosophical difference about it. So I don't know as if it's necessary to do that now. I'll certainly save that for the work session with my colleagues. And I appreciate your answer and your history with this, Mr. Vigu. Thank you.
Thank you.
Other questions for Mr. Vigu from the committee? Representative Barry?
Thank you, Mr. Chair. And Mr. Vigu, thank you for your testimony. You referenced Texas, which I think we, certainly on the electrical side of the street, we all, paid close attention to. There are clear lessons, in my view, to be drawn from that about reliability and investing in the grid. I'm less clear about the consequences if this legislation doesn't pass. I don't have cable myself. It's not an option where I live. So maybe you could help me understand that. If we were not to pass this bill, what do you anticipate the outcomes would be?
Well, the crystal ball is a little fuzzy here. Technology changes, but I can tell you a few things right off the top. One major concern is the unregulated use of the public right-of-way by new players without permissions or compensation to the municipality. Another one is there'll continue to be a steady decline in franchise fees due to cord cutting by cable subscribers if the new IPTV entrants aren't franchised to operate in the towns. Smaller towns with 2 or 3% franchise fees will not receive this automatic increase to 5%, paid quarterly beginning in January 2022, as the bill requires. And there'll be increased legal costs for as non-compliance issues continue to increase. There's currently no watchdog agency in Maine with the resources to investigate or prevent abuses by these operators. The lack of franchising and PUC oversight will foster a deregulated free-for-all for IPTV video service providers going forward. And I think it all comes down to who you're going to listen to. The cable industry, who will not profit from this legislation, or the people who work in Maine municipal government offices every day, telling you what they think. So I think, the absolutely legitimate staff requirements that are recommended by the PUC in that testimony, which you're going to hear, only gives credence to the helpless situation that the towns have operated in for years. Can you imagine a town clerk or town manager performing all the duties in dealing with a cable operator on all those issues in every town? The truth is that they try to the best of their ability, especially at renewal time. They just don't have the cable law background that the industry attorneys do. How much more efficient and professional it would be to have these resources available, if necessary, for the 340 municipalities to call upon, instead of the inequitable system that we have now, where the larger cities have the resources and the smaller towns don't. That's my opinion, and looking forward what I see.
Great. Thank you, Tony. Any follow-up questions? Any other questions from the committee? Seeing none, thank you very much, Tony. We're now going to go on to, and I apologize for looking in, but looking in at the screen, but sometimes it's hard for me to read people's moniker at the bottom of the screen. So we're now going to go on to Tom Handel. Unfortunately, our last two proponents did not join us in the waiting room. So if they join us, William Amaral and Melissa Sachs, we'll hear from them later. But the last proponent on this bill is Tom Handel of Portland. Tom?
Hi, yeah, I'm Tom Handel. I'm a resident of Portland, and I work for the Portland Media Center. I'd like to thank the committee for the opportunity to provide this testimony. And I actually just want to start off by adding to the answers that Tony gave for the last two questions, because for me, the essential service that this utility provides is freedom of speech. And the consequence of not passing this bill is basically losing another step in the foothold of free speech, because the constant evolution of information technology it challenges our freedom of speech. And each individual's ability to exercise their free speech is not only limited now by wealth, but by the skill level that they have to learn in order to access the number of ways that there are to be heard. And the Federal Cable Act attempted to address this when it first, during the advent of the cable television, by providing the assistance of public access stations, which was rightfully funded, as Tony mentioned, by the collecting franchise fees for the cable providers using public rights of way for profits. Now, cable television is much less frequently used because of the burgeoning vast array of different distribution options. And in response, public access stations are becoming community media centers like we are, where video professionals are now offering multiple types of media production and distribution to the people in their community to preserve the right to free speech. These video professionals who operate Maine's many community media centers are making a valiant effort to keep pace with the growth of media distribution technology. And the question is whether public policy will keep pace with these forward-thinking media centers and support their efforts to keep free speech accessible to everybody. Now, franchise fees have helped municipalities fund these public access stations out of the not out of the pockets of subscribers, because we all know that the cable companies will charge as much as the market will bear, but from a fee tied directly to the company's use of public rights of way to make a private profit. Why then shouldn't the public policy continue this rightful way to fund free speech by requiring providers of new services to pay what merely amounts to the cost of doing business? I urge the committee to vote LD 920 ought to pass for the simple reason that it makes sense. It preserves our freedom, and it allows public policy to advance with the technology it governs. Thank you.
Thank you very much, Tom. Are there questions from the committee? Seeing none, thank you. We'll now go on to opponents to the legislation. And we'll hear first from Benjamin Sanborn of the Telecommunications Association of Maine. Ben?
Senator Lawrence, I do. William Amaral did make it in.
Oh,
So
thank you.
At
So
least
we'll go
one
back to
more proponent.
proponents. I believe we have now William Amaral joining us. So William. We need you to turn on your video if you can and turn on your microphone.
Can you hear me?
I can hear you now.
Okay, I apologize for the location. I just got my COVID vaccine, so I'm at Scarborough Downs right now.
Okay, congratulations.
Yeah, it's pretty exciting. But it's a little, little odd to be doing this presentation here. I'm speaking in favor of LD 920.
Yes.
I'm the secretary for CTAM and worked somewhat on this bill a little bit. And I think it's an important bill for a couple of reasons. The primary reason is that it enables municipalities to have a tool in their toolkit other than litigation to deal with non-compliance issues with video service providers. And I think that is a really, really important part of this bill that we should sort of really focus on, because right now, if there's an issue with a cable operator, a municipality has no option but what is essentially the atomic bomb of canceling a franchise. Many other states have a dedicated state agency which is responsible for overseeing compliance, and Maine doesn't have that. So this bill should ease that burden on the municipalities and provide some state level oversight. I think that's the primary benefit that I see in this bill that we've worked on. Do we have any questions? I'm not sure what the format is here, so
Sure. We go to questions now. So I'll ask the committee members, do you have any questions for Mr. Amaral? Seeing none, thank you very much for testifying.
Yeah, and my apologies that it was so brief. It's kind of it's a weird circumstance that I'm in right now.
That's okay. And if you want to submit any written testimony, feel free to do it for the work session.
Sure, I've already done that.
Okay, great. So we'll go on to opponents, and we'll next hear from Ben Sanborn from TAM. Ben?
Thank you, Senator Lawrence, Representative Berry, members of the committee. My name is still Ben Sanborn, Executive Director and Counsel for Telecommunications Association of Maine, here to testify in opposition to LD 920. A little bit of background, there was discussion about the session, the stakeholder group session that occurred over this past summer. It was largely spurred because of a request from TAM, because we were looking at how to improve broadband investment in rural Maine and what roadblocks existed that could get removed. We noticed that there was an issue with regards to the costs of going through town-by-town negotiations for franchise agreements. However, we recognize the importance of franchise agreements and of supporting municipalities with franchise fees and PEG channels. So we proposed having a statewide franchise that would have a single franchise operated at the state level, overseen by the Attorney General for enforceability, that would allow people to come in and quickly receive a franchise to operate in the state. There would be franchise fees that would then be funneled to the municipalities in which they operated. There would be consumer protections that would be enforceable by the Attorney General. And it's something that we felt would assist communities in allowing them to maintain these essential services. At the same time, it would assist providers in allowing for a streamlined approach for entry into the market. We went through the process, and during the discussions over the summer, what had been a roadblock was turned into an impenetrable wall. And that's what this legislation is. It is a way to say we do not want investment in rural Maine, and we do not want IPTV. And what this bill does is, it's a little ironic because earlier today, there were a number of bills talking about the way in which we could reduce costs for getting broadband providers access to poles. Well, this would then turn around and slap a ongoing fee onto those exact same providers if they offered any video over their services, which is something that some providers might be looking into as a way to justify an expansion. And I want to be clear, there's more of this in my written testimony, but offering video service is a loss leader. The content costs are enormous, especially for a small carrier. And so we tend to lose money on the actual video service itself. And the only reason for engaging in this is to try and get more people to upgrade to a fiber offering so that it gives an economic justification for doing an expansion to fiber service, especially in rural parts of the state. I noted in my written testimony the attempts by Oxford Networks to do video service over fiber in downtown Lewiston. And they were able to get the fiber built out, but they couldn't make the video service work just because the content costs were so high. And so this is a situation where if this bill goes through, there will not be new IPTV that is going to be participating in this. The option is simply offer a Roku stick and 1 month of Hulu Live free and call it a day. And that's something that is not going to encourage new growth. That's something that's not going to encourage anybody to be investing in fiber in the state of Maine. So We did include in our testimony what we have proposed as a statewide franchise. We still think that that is an option that can and should be explored. We think that addresses all of the issues that have been raised here with regards to how do you get consumer protection? How do you have it enforceable? How do you make something that is going to be equitable for the towns? How do you ensure that there are going to be PEG obligations and franchise fees? All of this is addressed in what we have presented, but it does so in a manner that helps the municipalities and the incoming providers to promote competition and broadband expansion. With that, I'm happy to answer any questions.
Thank you. Are there questions from the committee for Mr. Sanborn? Seeing none, thank you very much.
Thank you.
We will continue with people testifying in opposition to this bill. And we will go to Chris Hodgson of Comcast. Chris?
Thank you, Senator. May I continue?
Yes, go right ahead.
Great, thank you. Senator Lawrence, Representative Barry, and members of the committee. My name is Chris Hodgson. I'm Comcast Vice President of Government Affairs in Maine. We serve 15 communities primarily in the area around Kittery, Elliott, Berwick, and then again up in the Mid-Coast region from Freeport to Woolwich. And I just want to offer our opposition to this today. I think our opposition is really founded in a number of areas. My written testimony, which is included, should cover it in some detail. I just wanted in my oral comments highlight a couple of things. I think fundamentally, we oppose this because it stands between the negotiation that we conduct between our communities that we serve and us. It is really a bill that basically elevates the interest of the public access community up and above the interest of the two other parties that are participating in these negotiations. And it raises the cost for our customers in a way that creates just not only additional competitive disparities for us, but also does it in a way that ignores the decisions and agreements that we've made with our local communities. And I'll winnow in on that a little bit. We in our 15 communities that we serve, 5 of them do not have and have chosen not to have a 5% franchise fee. And despite what you heard previously, I want to be clear, in a community with no franchise fee, the cost of the service at the bottom of the bill is less than in a community where there's a 5% franchise fee applied. The cost of the package before taxes and fees is the same everywhere. The differentiating point being the fees and taxes that are added to the bill. That means in our 15 communities, about 8,000 residences and businesses are going to see an increase in their bill, constituting somewhere around $300,000 a year. It may not seem like an enormous amount of money. I think we would disagree. I think we do believe that that is a substantial amount of money to add to those customers' bills, particularly since the towns have chosen either to have a 0% franchise fee, as is the case in Elliott, or something in between, which is the case in Kittery and Bowdoin, Bodenham, and South Berwick. The other issue in the bill, and it's item number 3 in my testimony, is that the extent to which PEG is part of a franchise is part of this negotiation between communities and their provider. And it may be the case that the PEG operators wish to have more investment either in their channels and their equipment or in how much money they receive from the community. But all of that is part of the agreement that is negotiated with the community. And if there are costs related to capital or facilities, those costs are included in an additional line item on the customer's bills. And that can be substantial. And based on the way this legislation is written,
just running a little bit up against the 3-minute deadline, Chris.
I'll wrap it up, Senator. Okay. That cost can be substantial. In fact, it can be 50% of the franchise fee, as we see in Kittery. So while it's not as easily understood as a 25-cent a month fee or 5% gross revenue fee, that additional cost, which this bill seeks to really make unbounded is very substantial. And we oppose it for that purpose, for that reason. We don't think that the state should stand in between the negotiations that we have with our local communities. We think that that system is fair to both us and them, and we'd ask you to oppose this legislation. Thank you, Senator.
Thank you very much. Are there questions for Chris from the committee? Seeing none, thank you. We'll go on to Damon Stewart from the Dish Network testifying against.
Hello, can you hear me?
Yes.
And I don't know why my video isn't working. I apologize. My name is Damon Stewart, and I want to thank Senator Lawrence, Representative Berry, and members of the committee for time to testify on this bill. I'm with Orrick, Harrington, and Sutcliffe, and I represent Dish Network and their subsidiary Sling, as well as the tens of thousands of Maine families and customers who subscribe to those services. Dish Network respectfully opposes this bill because it would set up a framework that could allow cities and towns in Maine to claim a vast, and we would argue inappropriate, expansion of franchise fee obligations on those that provide video services without any relationship to the occupation of the right-of-way, for which franchise fees are always typically imposed. In other words, as been said earlier, franchise fees are what municipalities charge cable companies for the right to place their cable in the right-of-way. They dig up streets and sidewalks and put the and put their cable lines in. Excuse me. Essentially, that's rent. In fact, I think that was even stated by Mr. Viggy earlier. Satellite companies have never paid franchise fees for the right to place cables in the public right of way because they don't have any. Their beams are, their video signal is delivered from space directly to the customer home via the satellite that you typically see on somebody's roof. And streaming companies also do not have infrastructure, their infrastructure in the right of way. Customers obtain video services typically through the use of the public internet. But this bill as written would allow cities and towns to attempt to seek franchise fees from anyone who provides video service, regardless of whether they have any infrastructure in the right of way. I would say the majority of families and businesses that have internet access probably have it through cable provided by their cable service. Cable pays their franchise fees, that'll get passed along to the customer and they pay that in the monthly bill. And I think it's a safe thing to say that most people have, in addition to say a video package with their cable company, they'll have Sling or they will have Netflix, Amazon, and so on. Under this bill as written, the municipalities could claim that for every such service, you get another 5% and another 5% and another 5%, despite the fact that the customer is paying 5% for that one single cable line that allows access to all these services. We could see a doubling, tripling, quadrupling, or more of the fees for this internet access. And I want to emphasize this is not a speculative concern. We have seen cities in other states do exactly that, claim franchise fees are owed based upon remarkably similar language that is in this bill.
Just so you know, Damon, you're running up against the 3-minute deadline.
I will conclude. In order to avoid the creation of litigation-ready legislation, to avoid the attempted imposition of layers upon layers upon layers of additional franchise fees per customer, for the same cable line that Dish or Sling does not own, operate, or maintain, we don't use the right of way. We respectfully urge the committee to reject the bill. And I am available for questions, and I can comment on the PEG issue if people have any questions about that.
Great. Are there questions from the committee? Seeing none, thank you very much. We'll continue with opponents to the bill. And we will go on to James Bass. James?
Good afternoon, Senator Lawrence, Representative Berry, members of the committee. My name is James Bass. I live in Augusta, and I'm here on behalf of the Motion Picture Association and its member companies. MPA members are the world's leading creators and distributors of motion pictures, television programs, and streaming productions. MPA members include Disney, Paramount, NBC Universal Studios, Netflix, Sony Pictures, and Warner Brothers. Excuse me. And member companies also own streaming services, including Disney Plus, Paramount Plus, HBO Max, Peacock, and Hulu. MPA would like to thank the sponsor. Over the last day or two, we've been in contact trying to work through some of our concerns with the bill. As drafted, I think the bill and the person who just spoke from DISH did a great job talking about its broad impact. There are concerns that the bill really would bring in not only sort of cable who's already in, but also streaming services and others. The main piece is that it has as the foundational, I would say that as the foundational center of the bill is the idea that streaming services use the public right of way, just like cable television. So, as we've talked about, those franchise fees that cable companies pay are because they own the cable that is strung on those poles. Streaming companies don't own the poles, they don't own the wires, so they really don't have that same, that same hook, that same jurisdiction in regards to a franchise fee. You heard from the sponsor, proponents, and Senator Rafferty that there's an interest in paying for upgrades. Sort of another reason why I think this bill, as drafted, is too broad and would bring in others who don't physically own those assets. Through the amendment that the sponsor put through earlier this morning, it would call out a video service provider as a public entity that may be regulated by the PUC. And as we've talked about the PUC with electric, gas, ferry service, it covers those industries where there's private ownership of those assets. And so Senator Stewart was talking earlier about sort of that 101 on electric law. In here, those streaming companies don't own those assets, right? I mean, they transmit content over the wire, but that wire is not owned by that company. I think another problematic component of the bill is that it would apply this franchise fee to a broad range of streaming services. So not only is it Hulu and Netflix that we're talking about, but it also would cover music, podcast, radio, audio and digital books, games, esports, etc. There's also a concern that what about those communities and those individuals who are already paying a franchise fee under the current regime? Would they also then be paying a 5% fee if they also are streaming Netflix or Hulu? So there's that concern.
We're coming up on the 3-minute deadline, just to know, Jay.
Understand. Thank you very much, Senator Lawrence. No other state has passed any other similar legislation. We asked the committee to take that into consideration. Again, MPA wishes to thank the sponsor for his communication and work through this. We're happy to work with the sponsor and the committee moving forward, but we do have those concerns. Thank you very much.
Thank you very much. We will go on to the next opponent, Melinda Kinney of Falmouth. Melinda?
Excuse me, Mr. Chair.
Yes.
I
apologize. You had a question.
Yes. Not a question. May I take a point of clarification about the bill?
Sure. Well, do you want to save it now or for the work session?
No, it's specifically addressing what the two past speakers had said. I just wanted to make it clear.
I just want to mention you don't get a chance to testify twice, but I'll let you make your clarification.
Yep. I just wanted to point committee members to page 2 of the bill under line 17. Which is in the definitions of video service provider. The intent of the bill is not to include those streaming services in which the past two speakers had reference to, and especially on line 26, the definition of an internet access service. So just wanted to clarify that that's not the intent of the bill, and if we need to work through some language tweaks, open to that. So,
okay. Thank you. And we'll go on to Melissa Kinney. Melissa? I can hear you.
You can?
Yep.
Oh, okay.
It's a little bit muted, but I can hear you. I'll just turn up the volume.
Is that better?
Yeah, it's really about the same, but we can hear you, so don't worry.
Yeah, I had asked Jordan to unmute my the landline that I'm on, but I don't think he did. So.
Okay, so whatever microphone you're working, we're getting an echo, so it's difficult to understand what you're saying.
Is that better?
No.
Is Jordan around? If you can unmute it.
Jordan?
Yeah, what can I
Are you
what can I
able
do?
to unmute her?
She is unmuted. I don't know if potentially she has the wrong microphone selected potentially in her audio settings or something like that.
All right. Hold on.
Okay.
Well, I'll just, if you can hear me okay, then I'll just roll with it.
Okay, give it a try, and if it gets difficult, we can always let you resolve it and then come back to you.
Sounds good. Sorry about that, you guys. So this is Chairman Lawrence, Chairman Barry, members of the Energy Utilities Technology Committee. My name is Melanie Kinney, a resident of Falmouth and with Charter Communications. LD 920, in our view, reflects a fundamental misunderstanding of today's video marketplace. Consumers have a lot of choices for how they receive their video content, whether it's through a cable provider, wireless, streaming service, or satellite. Actually, a recent report from the FCC showed a decline in subscribers of cable and satellite companies from 2015 to 2019, while the online video providers such as Netflix, Hulu, Amazon saw an increase of 150% during that same period of time. Our biggest concern with LD 920 is that it takes away municipal control and increases fees for Maine residents. Franchise fees, has been discussed earlier today, are passed through to consumers consistent with federal law. Over 110 Maine municipalities in Spectrum's footprint today select a 0% franchise fee, and 109 of our communities have a fee of less than 5%. And all of those customers would see an increase in their cable bill if this legislation passes. In total, we have 293 communities, and 218 of these communities have selected to be under the 5% federal fee cap. Portions of this legislation are also preempted under federal law, and legal challenges are likely to arise out of that. The proposed amendment from this morning, which defines video service providers as a public utility, is really a significant change. But if the goal is really just to redefine this as to simply assess a regulatory fee instead of the 25-cent fee that was suggested, that can really be done under the existing construct. There's a significant amount of Maine law that has been compiled over the decades regarding public utilities for gas and electric companies, and so just dropping in video service providers as a public utility really has significant impacts that would need to be fully analyzed. We feel that this bill is very narrowly focused and it takes away local control, and at the end of the day, it's going to have financial impacts to customers, and that's why we respectfully urge the committee to reject LD 920.
Great. Are there questions from the committee for Melissa? Seeing none, thank you very much. Our next opponent, Sarah Davis, wasn't able to make it, so I'm going to temporarily go back to a proponent who was in another committee while we were doing proponents, and we'll recognize Representative Melissa Sachs. Melissa?
Thank you. I'm Melanie, but thank you so
Melanie,
much,
I
Senator
apologize.
Lawrence. It's all right. You've had
You're on our
I've popped
list
in
as
and out
Melissa.
all day long. I have seen how long you all have been here. Thank you so much for
Yeah.
allowing me to be here on my third committee today. So thank you so much. But this was really important to me. So thank you, Senator Lawrence, Representative Barry, and esteemed members of the Joint Standing Committee of Energy, Utilities, and Technology. I'm submitting this testimony today as a co-sponsor and a strong supporter of LD 920. You've probably heard excellent testimony about the value of PEG programming to municipalities. As a former town councilor for 6 years here in Freeport, I can truly attest to the significant community value. Often stopped at my local market saying, I saw you on TV last night, from folks who couldn't have otherwise accessed civic engagement. So it's civic engagement at its best. But for me, this bill, LD 920, is more than recognizing just the value of the service. It seeks to rectify inequities in the evolving communications landscape. And I caught a little bit of the testimony of those who are against this legislation. I'd like to address, really to highlight just the inequities and what this bill serves to try and solve. What problem is it trying to solve? So I've submitted this in writing. I will go through it very briefly. That number one, these definitions that Representative Kessler also pointed your attention to is really important. As we have the evolving landscapes, we would like to capture those that are not included, but of course not do those that should not be impacted by this legislation. So these definitions are very, very important to clarify. Secondly, the second point for municipalities is the realizations that, and this is in practice, that video service providers right now are not interested in doing these franchise agreements. This creates parity, as it has been within this space for years. It's saying anybody within this entity must pay that franchise fee, the same fee that other cable operators have been paying in the past, and it standardizes. So the third part is standardizing it. I'd like to note in my testimony where according to CTAM, their analysis is often municipalities may not know that there's a 5% fee that is mandated by law that you can charge, because they say that consumer complaints go up. For those that do charge that 5% fee, they do not see that preponderance of complaints. And it will provide a stable funding source for these municipalities to continue this critical programming for their communities. I'd also like to point out that within the statute, by defining, again, facilities, because, and I cite law, I'm a data geek, so there's Title 30 cited in my testimony that talks about that all franchises must include provision for access to and facilities to make use of these PEGs. So again, the definitions are really important because facilities is not defined. If the cable operator and future video services providers must own, upgrade, and maintain the equipment, as they have always done within this expanded definition, that continues on a tradition that has always been there. And the key point about this is that I provide evidence of what is happening in this marketplace right now. Municipalities are being asked for thousands of dollars worth of fees that they have not budgeted for and cannot come out of their pockets in this way, plus a substantial monthly fee. And so that's documented in my testimony. So this isn't a maybe someday, this is happening right now for your local municipalities that you serve. And finally, just talking about the consumer protections that are in there, the oversight, which there had been none within this industry before, and having it go under the Public Utilities Commission, as well as having the municipality and the Attorney General have the ability to bring some enforcement action. So these are really critical consumer protections and municipal protections as well. These are just some of the ways that LD 920 seeks to create parities among the communication providers. It helps to protect Maine consumers and support our municipalities, which is one of the major reasons that I'm here, while sustaining this important community service. Thank you so much for letting me pop in. I urge you to unanimously support LD 920, and I'm happy to answer any questions that I can. I just raced through that 3-page testimony as quickly as possible.
Thank you. Are there questions from the committee for Representative Sachs? Seeing none, thank you very much.
Thank you so much again for
We'll
allowing
now
me to
go
be
on
here.
to people testifying neither for nor against, and I'll recognize the public advocate, Barry Hobbins. Barry?
Thank you very much, Senator Lawrence, Representative Barry, and members of the committee. My name is Barry Hobbins, and I'm the public advocate speaking today, neither for nor against LD 920. The Office of the Public Advocate was asked last year during the 129th legislature by the two chairs of the Energy, Utilities, and Technology Committee to assemble stakeholders with the task of addressing many of the issues addressed in this bill. We would be happy to distribute the study for the work session, and the link can be found in my testimony. In brief summary, what the office found, that there were a vast array of interest around this subject. While this bill may be a step in the right direction, there is still considerable amount of work that must be done. Perhaps the biggest problem with the bill is to address the potential financial loss of the municipalities because of the franchise fees. Also, the arguments by the Maine Municipal Association, as a member of the stakeholder group, focused on the loss of local control. And as you probably know, that's always a hard policy stance, and it is very difficult for public policy individuals, such as legislators, to deal with that particular issue, because it is an issue. In addition, the OPA is concerned about this bill because it could find itself in the same place that two of the bills which we were in favor of last session that were challenged by the cable industry. And basically there's one bill, I believe, still in court and alive. The other one was overturned about 6 weeks ago. And that is in relationship to the Federal Cable Act. This federal preemption issue is out there, and it's something that it has to be, if it's going to be addressed, it has to be addressed very well. Fortunately, our Attorney General's office, Christopher Tabb, did an excellent job in court. But quite frankly, compared to the lawyers on the other side, he was sitting there with one particular lawyer, and the other side of the room were lawyers from all over the country that flew in their jets. So quite frankly, it was a difficult task to overturn those issues. But I believe that if these issues can be addressed somehow, that there really needs to be another issue that's addressed, and that is the industry has to do something about the public access issue. I think the testimony was very compelling today by many of the individuals who believe in local community television and public access. And for whatever reason, there seems to be a lack of communication between the two, because these bills are going to come up every single session, and maybe the cable industry will finally wake up to address these issues. That's a little bit of editorial comment on my behalf, but this bill will come up again and again and again. And I can tell you, when you read the stakeholders report, you will see how frustrating the whole process is. We had 5 different meetings. We did all stakeholders, which were addressed and requested by Senator Lawrence and Representative Berry. And we obviously felt an obligation out of respect to those individuals, those 2 chairs and the committee, to attempt to be used as a conduit. We tried, but there's so many differing opinions. But
thank you.
Thank you very much.
Thank you very much. Are there questions for the public advocate from the committee? Representative Berry.
Thank you, Mr. Chair, and thank you, Mr. Hobbins. Mr. Hobbins, you referenced 2 bills that were passed by this committee 2 years ago that were challenged, and that to date, I think are under consideration for possible appeal. I don't think that those bills that either of them were brought by the Community Television Association of Maine, which, as I understand, is backing this legislation. I think the bill that I'm recalling did in fact become law. That was LD 1371, which had to do with non-discriminatory access and became Public Law 245. So I just wanted to make sure that we're in agreement about that history.
You understand is that this committee last session really addressed some very difficult issues and quite frankly did a good job of balancing the different sides. Unfortunately, the next step is the step where it's difficult with the constitutional issues involved in federal preemption with the FCC, and that those issues you have to demonstrate the bar is very, very high. I commend the committee for enacting the bill you're talking about. The other bills, quite frankly, could have gone either way. I wish they would have gone a different way, but that's my personal opinion, and also was the opinion of our office. Thank you very much for bringing that up, Representative.
All set. Thank you.
Any other questions for the public advocate? Seeing none, I'll go on to.
If I could ask if you would like the senior counsel, Nanette Audrey, who coordinated the stakeholder group on behalf of the stakeholders, I'd be more than happy to ask her to attend the work session if that's of interest to you. I attended every one of them, but she worked behind the scenes with research and the like and did a very good job.
That would be helpful if you could ask her. Thank you. We'll continue with those testifying neither for nor against. We'll go on to Neil Goldberg of the Maine Municipal Association. Neil?
Good afternoon, everyone. Senator Lawrence, Representative Berry, and members of the Energy, Utilities, and Technology Committee. My name is Neil Goldberg, and I am providing testimony neither for nor against LD 920 on behalf of Maine Municipal Association's Legislative Policy Committee. I have to say it's great to hear so many people today concerned about the loss of local control that this bill would create. But our members actually feel that there is some value in a statewide approach to franchise fees, as long as that approach both prioritizes the modern technologies that our communities depend on, as well as doesn't interfere with federal communications commission orders, as the public advocate mentioned just a moment ago. Municipalities would like to see, if these franchise fees go forward, that, as we mentioned, they prioritize the new technologies like 5G or fiber optic, high definition video channels. At the moment, it does feel that franchise fees keep municipalities and video service providers tied together in agreements that push forward the same technology that's existed since these franchise fees came into existence. And so as we reconsider those arrangements, we should be prioritizing modern priorities. There's also an impact to the ratepayer of our residents. All municipalities will be impacted by this, not just those that aren't assessing franchise fees at the moment. But half of our members are foregoing that option in an effort to save residents expenditures. And this would obviously change that for everybody. The issue of a regulatory surcharge was addressed by the amendment that was introduced earlier today. And so we see no issue with that if it was to go forward. And so respectfully say that we hope that you consider the pros and cons to this bill, and we'd be happy to provide more information at the work session. Thank you.
Thank you very much. Are there questions from the committee for Mr. Goldberg? Seeing none, thank you. Just for the committee's information, we have 2 more to go on neither for nor against that'll likely take us up somewhere around a little bit after 1 o'clock. We're going to be breaking before the final bill for lunch, and we will be back at 2 o'clock for the public hearing on the final bill. We'll now go to, I do not see Orion Breen and Jordan. Is Orion not going to be testifying?
He's not currently in the Zoom, so Garrett Corbin will be next, but if Orion pops back in, I will add him as a panelist.
Thank you. So we'll go on to Garrett Corbin from the PUC. Garrett?
Okay, good afternoon, Senator Lawrence, Representative Berry, and members of the committee. Once again, I am cognizant that I am the, sounds like the last person before lunch, so I'll try to keep it brief, but you won't be surprised to hear that we've got a decent amount of consideration given to the impact on the commission of this bill. It's been affectionately referred to in-house here as the bigger boat bill, referencing the tagline from the classic movie Jaws, that we'll need a bigger boat. So our testimony is, I'll get on with here, is explaining how the commission, there would be a significant staff impact, which I know the opponents are aware and had considered. As has been discussed already, this legislation, which again, the PUC is neither for nor against, proposes a substantial new degree of cable TV regulation at the state level. Video service providers amended recently, including resolving franchise disputes between municipalities and video service providers, handling complaints from consumers regarding the quality of service, notwithstanding any federal preemption issues that I'll address towards the end. In addition to the many revisions to the law governing franchise agreements between municipalities and video service providers, or VSPs, Act requires the Commission to engage in no fewer than 20 new activities. Section 15 of the Act provides the Commission with the authority to regulate VSPs through the adoption of routine technical rules, and our written testimony outlines the new regulatory activities assigned to the Commission, which I won't review right now, but it's important for the committee to be apprised of the breadth of what would be required. Probably not surprisingly to you, regulation of these items is expected again to entail significant effort on the part of the commission. It's difficult to anticipate the number of franchisees or subscribers who would seek relief through the commission. Impact could be acute in the first few years after enactment, in the event of a backlog of existing unresolved grievances brought to what would be a new dispute resolution tribunal in the commission as the Act envisions. On an ongoing basis, should the commission be required to resolve thousands of subscriber complaints, we anticipate that would require several additional staff in the Consumer Assistance and Safety Division, CAD, as well as other commission staff impacts. Section 20 of the Act proposes a notice requirement to customers of their ability to file complaints. Current statute provides consumer complaints would be filed with the Office of the Attorney General. So I'll harken back to previous testimony where consumer dispute matters are generally in the AG's purview. Given the number of consumers in Maine that subscribe to a video service provider, the commission anticipates the volume of complaints would be similar to those received concerning the electric industry. So in that context, the additional staff required to handle the increased workload would initially be 2 attorneys, 3 utility analysts, 6 additional CAD specialists, and 1 CAD supervisor. On the other hand, should the committee choose to remove the requirement that the commission resolve consumer complaints, the new staff required by the commission would be significantly reduced. The commission anticipates 1 attorney, 1 utility analyst, and 2 CAD specialists would be required to provide dispute resolution and other services strictly related to franchise agreements. That would also avoid complex jurisdictional issues and potential consumer confusion. Got additional detail in the testimony about the federal regulation of cable. Of course, franchise regulation is not necessarily preempted by federal law, but the additional consumer protections, that's where I think things get a little bit more gray. So until there's clarity on that, there could be a decent amount of uncertainty and complexity during a transition to more robust state level oversight. And there's a concern that practical impact could be frustration on the part of consumers and considerable impact on the commission. So again, current consumer protection responsibility lies with the AG. Other provisions, just our written testimony ends with 3 things the commission recommends the committee give more consideration to before it moves forward with this proposal, which is first, which aspects of cable video services are within Maine's regulatory jurisdiction. Second, the extent to which laws regarding broadband services would dovetail or overlap with that jurisdiction. And third, that delineation between PUC and Attorney General or other state entity jurisdiction. With that, I'd welcome any questions, and of course, we'll be available for the work session.
Thank you very much. Are there questions for the PUC from the committee? Yes, Representative Wadsworth.
Thank you, Mr. Chair. So, Mr. Corbin, do you think there'll be a fiscal note associated with this bill where it sounds like you might have to staff up?
Sure. Thanks for the question, Representative Wadsworth. I think a fiscal note might ask, once the details are sorted out, whether it's the printed bill or an amended version, that if it moved forward, that's when we're usually asked for a fiscal estimate based on that final language. And so we'd probably try to respond with a specific fiscal estimate at that point. But then that's just one, that's sort of the first side of the fiscal note coin. The other side is not just what the anticipated impact would be, but also whether it could be absorbed with existing resources or whether we need new resources. And so this, I think the proposal, whether it's the amended version or the printed bill, tries to, I think, envisions that and gets ahead of it by acknowledging there will be a provision for fees or an assessment there to cover that cost. So we'd be estimating the impact, but also the language would probably provide for that. It would be different than having a fiscal note that sends it to the Appropriations Committee for a general fund apportionment, for instance. And the only other thing, I guess, along those lines that I might mention real quick is just that we'd envision, if this did move forward, we'd envision a time necessary to staff up for this, so to speak. So, I don't think the commission could be expected on day one of the bill's effective, after its effective date to prepared. Again, we need to take on that new staff before we could really move forward with the regulation and vision.
Got it. Thank you.
Thank you. Other questions for the PUC from the committee? Thank you very much, Garrett.
Thank you.
And we do have Mr. Breen coming back, so we can go back to him. And so I'll recognize Orion Breen testifying neither for nor against.
Thank you. Honorable members of the Committee on Energy, Utilities, and Technology. I like to hear what people are doing in the community, what makes them and the community unique, what they like and what they are like. I don't like a machine or algorithm telling me what I should like. I don't want my behavior predicted based upon past likes. I like to be genuinely surprised, to be given the chance to like or dislike something just because I do, not because I'm being sold something. That's some of the reasons I like community television. When you tune into community television, these are your neighbors, real people sharing their ideas and passions. That's pretty cool, and unfortunately, pretty rare these days to have any kind of public platform that is not controlled by a private entity. If we don't step up, it will become even rarer. We need to make sure municipalities have the funds to record and broadcast things like town meetings that are essential to good citizenship and democracy, and have been even more important this past year as the pandemic severely limited accessibility to so many important things happening in our hometowns. I urge you to think creatively about ways the state can support community television and platforms of free speech accessible to all citizens. While my understanding of technical and legal issues is very limited, I hope your decisions will be guided by the expertise of folks like the Community Television Association of Maine. Thank you.
Thank you. So Orion, we had you listed as neither for nor against. Should you be listed as testifying in favor of this legislation?
I put neither for nor against because I am not a technical or legal expert. But I think that if for some reason there's details in this bill that need to work out, that people in this committee think creatively about ways the state can continue to support community television with rules like this or a modified version of it, and working with folks like the Community Television Association of Maine to do so.
Okay, great. Thank you. Are there questions for Mr. Breen from the committee? Seeing none, thank you. I will declare the hearing on LD 920 closed. And we are going to our lunch break, and we will be back at 2 o'clock. So please stop your video and mute your audio.
Steve, I'd like to ask you a question if I could.
Just so you know, Paige, we're still live streaming.
It's nothing personal.
That's
This is
okay.
about a bill. I would never ask an engineer something personal.
Sure.
Yeah, Dave Mearmount has a bill in ENR about imports, you know, in California where you can't, the low sulfur issues and so forth, and they're compliant, but nowhere in the East Coast, the Coast Guard regulates all of the air emissions control. Have you ever put into a Maine port at all?
I certainly have, but it was many years ago.
Okay,
My first career.
Yeah. I was just wondering, it doesn't seem like we have a tremendous amount of ship traffic. And, you know, we in Portland and we have Searsport, but really, and some Eastport, but I mean, do you think we really have enough ship traffic that we should be concerned about it?
I don't think there's very much. The folks that live in Portland, South Portland, see probably as much as anybody
Yeah.
when those tankers come in. But other than that,
Well,
there's not a lot.
they've converted from the sulfur, right? I mean, it's just the same analogous to any other port. So they're going to be burning as clean a fuel as they can. Am I correct on that?
Yes, I believe so. And I think, you know, most now are diesels and they're burning
Yeah.
that, but they also, I believe, have increased the technology on exhaust scrubbing and that type of part of it as well. But
Well, it's Dave Miramont's bill, so that's all I'm going to say.
okay, I'll if I get a chance, I'll look for it. Thank you.
Glad we didn't start back up super tight at 2. I was busy getting my butt handed to me by my 13-year-old in chess at lunch. So
that's what's important.
Yep. There was a day when I could just open and play a really aggressive game of chess with him. And I just found out very clearly that day is over.
That's a good sign.
It is. He's learning really fast. It's great.
Yeah.
So I was told by Senator Lawrence that we are live, Scott. So across the world right now, they're thinking you're a lousy chess player and you use.
I'm actually perfectly fine with that.
I'm not a bad chess player. Unfortunately, he's significantly better though.
I think I might have been better at 13 than I would be now, though. So
yeah, probably not wrong. Chess team was good.
So were you a member of the chess club in high school?
I did chess club in middle school. We had middle school chess, and then I did not play in high school.
yeah, that's where we had ours too in middle school.
Yeah. We had track was in direct competition with chess. You had to pick one or the other in high school, if I remember right.
Well, there were other sports that became more important in high school as well.
Yeah. Yeah.
That was the same thing with me in band. You know, I decided I didn't want to play the cornet anymore. I wanted to run track and cross country. How are we doing for numbers? 1, 2, 3, 4, 5, 6, 7. Looks like we're ready to go. And Jordan and Dan are here. We've got one bill left. So let's get to it. We are back. So Jordan, do we have Senator Maxman here?
We don't, but I believe that Representative Barry will be presenting on our behalf.
Are you going to do that for Chloe? Okay, good.
That's right.
And I assume we have Barry Hobbins in waiting?
Yeah, I just put him into panelists.
Okay. Why don't you put him and David Costello in, and we'll get started. Great, we're back. Obviously, we're on the air still, and we're going to have a bill presented, LD 815, an act to support school decarbonization. The sponsor of the bill is Senator Chloe Maxman, and unfortunately, she can't be here today, so pinch hitting for us is the representative co-chair of this committee, Representative Berry. You're going to present the bill.
Thank you, Senator Lawrence, and fellow members of the committee. I am not Chloe Maxman, but I'll do my best to stand in and simply read you her testimony. Members of the committee, my name is Chloe Maxman. Her testimony reads, I represent Senate District 13, which includes all of Lincoln County except for Dresden, plus Washington and Windsor, a total of 27 towns. Thank you for the opportunity to speak in support of LD 815, an act to support school decarbonization. LD 815 is a bill to update LD 1282, one of my bills that was passed last session. Subsequent changes to state and federal law prompted Efficiency Maine to reach out and ask for an improvement of this program. Efficiency Maine will be here today to talk more in depth about the need for this bill and what this legislation can provide. Last session, I introduced legislation that included support for schools as they navigate the renewable energy landscape. I did this because I did not want our school budgets, and therefore our property taxpayers, to bear the brunt of a changing energy economy. This is still an important service to provide our educational institutions, and so we are upgrading this idea. LD 815 creates a program within Efficiency Maine that provides technical and financial support to schools that seek to go carbon neutral. These services include, but are not limited to, facilitating access to legal resources and energy audits, to financial assistance, as well as incentive programs for schools. This program comes at no cost to school districts. This bill, to me, is an exciting opportunity to provide support to our school districts as they navigate a very complicated landscape. I know that we all hear about the property tax burden in our communities, especially rural communities like mine. This is a small way to support schools and therefore our taxpayers that will inevitably face the challenges of finding alternative and affordable energy sources. This, to me, is an example of a just transition that ensures that no community is disproportionately impacted by the evolving energy landscape. I appreciate the committee's attention to this legislation, and I won't offer to answer any questions on behalf of Senator Maxman because I am not Senator Maxman, but I'm happy to turn this bill over to the committee on her behalf.
Thank you very much. Are there any questions for Representative Berry? Seeing none, we'll go on to people testifying in favor of this legislation, and I'll recognize the public advocate, Barry Hobbins.
Thank you very much, Senator Lawrence, Representative Berry, members of the Energy, Utilities, and Technology Committee. I'm Barry Hobbins. I'm here on behalf of the Office of the Public Advocate and as public advocate with respect to LD 815. And we would like to be recorded as favoring this particular bill. First of all, I'd like to thank Senator Maxman for sponsoring the bill, Representative Grahowski, I believe, and Representative Berry, the co-sponsor of the bill. We believe it's important to shift from a school energy savings program currently administered by Efficiency Maine Trust to the ambitious goal of assisting K through 12 schools in Maine become carbon neutral via cooperative efforts of Efficiency Maine Trust and the Maine Department of Education. Another benefit of this bill is that it will help achieve the climate goals set forth by the Climate Council that was established by Governor Mills. Reducing the carbon footprint in Maine schools by making them more energy efficient will lower the cost to heat and power these schools and will save Mainers money while addressing the climate crisis at the same time. The Office of the Public Advocate would like some clarity on the repeal of the school solar energy program. And the question I raise, maybe someone will have the answer, would this program be rolled into the new law, or is the bill taking a broader approach that is not specific to solar projects? And I don't know if anyone has the answer to that question. I would appreciate it, but we do support this bill, and we look forward to working with you at the work session on LD 815. Are any questions? I'd be more than happy to answer.
Are there any questions, Mr. Robbins, from the committee?
Thank you.
Seeing none, thank you very much. We'll now go on to David Costello of the Natural Resources Council of Maine. David?
Thank you, Senator Lawrence. Good afternoon, Representative Berry and distinguished members of the committee. My name is David Costello. I'm the Climate and Clean Energy Program Director at the Natural Resources Council of Maine, and I'm testifying today in support of LD 815. Reducing Maine's second largest source of greenhouse gas pollution, residential, commercial, and public buildings, will require that the state strengthens its building codes and standards and increases its incentives for energy efficiency improvements and expanded clean energy generation and usage. LD 815 will help in reducing Maine's energy consumption and greenhouse gas emissions by establishing a school decarbonization program to aid Maine schools in achieving carbon neutrality. This new decarbonization program largely accomplishes by facilitating access to and possibly supplying funds for professional services, including energy audits, technical support and financing, legal services, to assist in planning and design and procurement of construction projects and solar purchase agreements, for instance, or equipment. May also provide financial assistance for cost-effective energy efficiency measures identified in an energy audit or the plans, designs, and procurements of the school facility. LD 815's added support will not only help in reducing the state's greenhouse gas emissions, but will also aid in reducing school energy bills, increasing school building resilience, improving community shelters, lessening community tax burdens, increasing local economic benefits, and providing expanded health, well-being, and education benefits for both students and the community at large. Importantly, schools are at the center of most Maine communities, and clean energy schools will serve as a visible and compelling demonstration of the value of decarbonization practices and investments. And in doing so, spur further climate and clean energy action across the state. For these reasons, we urge the committee to join NRCM in supporting this important clean energy and energy efficiency initiative. Thank you for your consideration. I'd be happy to answer any questions.
Thank you. Are there any questions from the committee for Mr. Costello? Seeing none, thank you.
Thank you.
We'll now continue with proponents. We'll go to Michael Stoddard from the Efficiency Maine Trust.
Good afternoon, Chairman Lawrence and Representative Berry, members of the committee. My name is Michael Stoddard. I am the Executive Director of the Efficiency Maine Trust, and I appreciate the opportunity to testify today in favor of LD 815. As Representative Berry mentioned in the introduction, this was legislation. This is designed to update and improve legislation that was adopted back in 2019. And the key thing to know is that school solar energy program, as we called it at the time, was passed earlier in the session prior to the enactment of LD 1711, which was as you know, the net energy billing provisions and some of the distributed generation resources provisions, and also the changes to the RPS and LD 1494. And to make a long story short, as Efficiency Maine started the process of rulemaking to implement the school solar energy program, we started talking to stakeholders. And in the course of doing that, we came to realize that this program idea had really been overtaken by events. the policies that were enacted with the net energy billing and the RPS were more attractive to schools. And there was a real possibility that if we went forward with trying to implement this school solar energy program, it was going to put them in a less advantageous position and would not be something that they would probably be interested in doing. It was complicated. It was small. We had size limits in the program that were statutorily set, and the incentives probably would not be as attractive. So at that point, we stopped the process of rulemaking and reached back out to Senator Maxman to see if, together with the stakeholders, we could think of something that would be more useful for the schools, since it seems like the financial incentives of solar were really pretty well taken care of with some of the other policies that have been enacted. And what we found ourselves pointing to, and this was with really significant help from solar developers and the attorneys who represent a lot of schools in Maine, is that the process for them, for the schools, is very challenging and sometimes overwhelming. It's complex, it's confusing, and we're familiar with that in our programs because we deal with lots of different types of customers, and sometimes big, complex energy projects can be overwhelming. And so there's a real barrier to people moving forward sometimes with projects that would be very advantageous economically and environmentally, but it's just too intimidating. And so the collective thought was that perhaps we could take some of the expertise that we have and the relationships that we have and some of the financial resources that we have and work with schools who are doing new construction projects or other kinds of energy upgrade projects to help them get the services that they need. I would take a slight exception or clarification, I should say, to Senator Maxman's testimony. I was assuming that there would be some kind of cost contribution, customer contribution to the cost of these projects. We have a technical assistance program that we run with large factories right now, where we cost share the technical assistance cost by 50-50. Something like that ensures that the customer has some skin in the game and they're serious about moving forward with a project, and we can help guide them towards a project that will be cost effective. And we think that this, for the same reasons that Mr. Costello said, could be extremely valuable in pushing forward not only better economic and lower operating costs for the schools and the taxpayers who pay for the schools, but also helping to advance the goals of the Maine Climate Council's new plan. So we do like the idea that this would be broader than just solar. It could extend to low carbon heating systems and improvements to the building envelope. So it's a little bit broader, which I like. And I think we can then customize projects to whatever is the most needed and the most appropriate for any given school building. And so for those reasons, we are happy to support this legislation, and I'd be happy to answer any questions.
Any questions from the committee for Mr. Stoddard? Oh, I apologize, Representative Wood.
Thank you, Mr. Chair. Mr. Stoddard, I was going to ask a question which you've sort of answered, and that is that in Senator Maxman's testimony, she said there was no cost to the customer. And so my question was, where were you going to get the money from? So since you've already brought that up as a point of clarification, I just hope in the work session that we can have further conversation about the finances on this.
Yeah, if I could just take a shot at at least a partial answer at this time, maybe it's sufficient. The first thing that I know one thing that Senator Maxman was concerned about is she didn't want there to be the perception that any school would have an obligation or any kind of a mandate that they would have to do any of these projects. And I'm pretty sure that this bill is clear that no one is obligated to do these things. It's an option if they elect to do these things. So I think what she was trying to highlight was that there would be no cost required if a school opted not to take any steps. So that's a partial answer. That then is complemented by my point, which is, given my druthers, I would would craft this so that there would be some contribution from the schools towards the cost of these, what we call soft costs. Just a common example is that we sometimes split those costs 50-50. These are not hundreds of thousands of dollars of costs. These are much smaller than that. So hopefully something that they could afford if they were serious about going forward with the project, but also something that we could really help with. The last point I would make is we do some of this already, and we have programs already. We've been very active throughout this past year of COVID, working with schools, because it turned out to be a pretty good opportunity since a lot of the schools were empty for much of the year. So we did major lighting renovations in many, many schools. It was tremendously successful, kept a lot of contractors working, and it's going to make those schools lower cost to operate and better lighting. So we are now seeing the shift to HVAC, heating, ventilation, and air conditioning. All of that is now what schools are looking at, especially because there is a significant amount of federal funds, as you know, that is coming as a result of several of the pieces of federal legislation over the last year. And so I think the timing is good, because I think a lot of them are going to be looking at what they can do with their buildings. And so I think a lot of the costs could be covered through those existing resources.
Good, thank you. That was helpful.
Great. Representative Foster.
Thank you, Mr. Chair. I do have a couple of questions, if it'll allow me.
Yes.
Thank you, Mr. Stoddard, for your testimony. I'm wondering, as far as new construction goes, which quite often the state funds a very significant portion of new school construction. And for an example of that, probably 12 years or so ago, during the planning and building of a new primary middle school in my town of Dexter, working with the state DOE, there was funding found to provide for a wood chip boiler, and which greatly diminished the amount of money spent on oil subsequently. And also building design, even back that long ago, was set up so that student population, when they were in the building, provided a lot of the energy needs, if you will, for heating the building. So I'm sure that those things have increased. I'm wondering, did Efficiency Maine have any connection or discussions or any involvement with that project, or do you with new building construction now with the DOE?
I am not recalling that particular project, Representative. It doesn't mean that we weren't involved with it. I'm just not aware of it myself. And I think one of the things that the way I'm reading this bill is that this would open up the range of activities to include existing buildings, existing school buildings that may be looking to retrofit some part of their energy system or their building envelope. And so it wouldn't be limited. The legislation that was passed 2 years ago was exclusively limited to new construction of projects that were approved to be at the top of the list of the state funding, which, as I understand it, was only 2 or 3 schools per year. And so this, I think, would be much broader in its application to not only do the new schools, but existing. We do talk quite regularly to the folks at Department of Education, and they have a great team there that's very involved, as you rightly point out, in new construction projects. The building codes are quite good, and the folks at Department of Education are very good. And so I have the impression that those new school projects are doing a very good job generally. And so it doesn't surprise me that they looked around at their options and may have found a wood heating system that they thought was going to suit their needs and advance their objectives. So I would expect to see a lot more of that, especially with all the federal funding that's coming to to schools and municipalities.
Thank you, Mr. Chair, if I may.
Yes, continue, Representative Foster.
Thank you. Thank you, Mr. Stoddard. The reason I bring that up is because obviously there are multiple opportunities for funding, and even I recognize the fact that you are probably more involved with older buildings and trying to make improvements. But even with that, the Department of Education quite often has some pretty stringent rules, if you will, on how they will help fund even maintenance or retrofit on existing buildings. So I would assume that, when those projects come up, their school administrators are looking to not only for your help, but also for DOE approvals where the DOE money may be a substantial part of the project. Do you know if that's happening?
Well, we're going to certainly want to continue coordinating with them. If you note in the section of the statute that this bill purports to amend, there's a little sentence there at the end that talks about us continuing collaboration with the Department of Education. So anytime they're doing a new school project, we're checking in to see if any of our existing programs would be a fit for something that they're planning to do at the school. But as you know, part of the way we do our cost effectiveness screen for eligibility is to try to establish what it is that would be incremental about a project, something that costs more but also has more savings. And to meet the cost effectiveness test, the value of that added savings would have to exceed that incremental cost. The thing about new construction projects is the code is really set quite high. The bar is set quite high in terms of energy efficiency. And so a lot of times in new construction projects, it is hard to find something that you could do incrementally more advanced than what the code is and have the marginal savings from that exceed what the cost would be. So we don't find ourselves getting very active in new construction projects. There tend to be more cost-effective opportunities in the retrofits. And of course, there are many more of those buildings. And then for the final reason you just pointed to is there tends to be quite a bit of public dollars at the ready to support new construction, not so much with retrofits. So that's where we have found ourselves focusing for the most part.
If I may, Mr. Chair. Yes, and finally, Mr. Stoddard, we learned when solar panels were installed at the Blaine House property that due to federal regulation, the federal subsidies weren't available for that work. I'm wondering, is that something that is also true for government properties such as schools or is that just completely a separate issue? Thank you.
The federal tax credit, and I just want to start with a disclaimer that I'm not an expert on this, and I'm sure there are other people who are before you regularly who would be better suited to answer this. But the federal tax credit is obviously only valuable to somebody who has a tax obligation that they can offset with the credit. Nonprofit entities don't have such a tax obligation. So state governments, municipalities, schools do not by themselves typically have that kind of a tax obligation against which they could apply the credit. But there is a workaround that can be done, and that is someone else can build and own and operate the solar project at that property for a time. And that's what you see with these power purchase agreements. You see a PPA that is held by someone who's an investor. They have a tax obligation. They use the tax credit to, as I understand it, to apply the credit to, and then they factor that into the buyout or the term of the project so that it benefits from the reduced cost and that's how they handle that situation. There are some other workarounds too, but that's the one I'm aware of with regard to PPAs.
Thank you.
Are you all set, Representative Foster? Okay. Representative Ziegler.
Yes, good afternoon. Good afternoon, Mr. Stoddard. When I was the chair of a school board about 5 or 6 years ago, we got grants from the DOE and worked with Siemens to do an energy audit, energy efficiency, and we reduced our energy use, which then folded over and Siemens, the more that they could reduce our energy use, the better they made on the contract. We also looked at solar, and the school has to own the land. In most cases, this was then, I don't know what now, it is now, the state owns the land, and you can't do that public-private thing where you sell off your credits. You get the electricity and they get the credits. So we were lucky enough to actually have the school district own the land so we could do as we wanted to. So this has been going on for a while. This is nothing new. And Siemens also had to produce a STEM course for the students to explain to them whether HVAC and that we put a boiler in, all those and lighting, all that was going on. So I think it's great that you're getting more money, that you're doing it, but it has been going on through grants previously.
Is there a question there?
Isn't that so?
Mr. Stoddard?
It sounds like it is.
Okay, good. Another question? Seeing none, thank you very much, Michael.
Thank you.
And now, unfortunately, Stephen Weems cannot join us today, but he has submitted written testimony, which I direct the committee's attention to. We'll go on to the next person testifying in favor of this legislation, and that is Melissa Winnie from the Governor's Energy Office. Melissa?
Great. Good afternoon, Senator Lawrence, Representative Berry, members of the EUT committee. My name is Melissa Winnie, and I am the Energy Policy Analyst for the Governor's Energy Office. The GEO testifies in support of LD 815 today. As has been referenced, the Maine Climate Council's Climate Action Plan does have recommendations that be supported by this legislation. Among other relevant recommendations, one of them is to enhance programs to support efficiency and renewable energy programs for publicly funded buildings such as schools. And I did link in my testimony to the full report, so you can take a look at some of the other recommendations related to reducing emissions in the building sector. I'd also like to bring your attention to another report that was recently released, and I did send a link along to committee members. And this is the Lead by Example report that was directed by Governor Mills. And this outlines strategies to curb state agencies' greenhouse gas emissions, transition state electricity use to 100% clean power by 2024, and purchase 100% electric vehicles for the state fleet by 2030. And I also linked to that report in my testimony. As state government works to lead by example, it's vital for other public entities to also do what they can to lead the efforts to combat climate change, and this includes schools and other publicly funded buildings. As has also been mentioned today, these strategies have added benefit of reduced operating costs, and that results in savings to taxpayers. And we've also seen tremendous support from students and youth leaders who have pushed the state to support efforts to reduce emissions in their schools. So on behalf of the governor and the Maine Climate Council, the GEO is supportive of this legislation that would continue to establish these resources for schools working to decarbonize and aid Maine in meeting our overall state climate and clean energy goals. With the leadership and technical and financial assistance that would be made available by Efficiency Maine Trust, these schools would have access to the resources they need to make these cost-effective decisions. And as the schools utilize this program to meet these goals, schools across the state will be able to learn from their efforts, as well as the communities in which the schools are located, so that there's additional knowledge share in terms of being able to meet their own climate and clean energy efforts. And all entities in the state really will need to engage in reducing greenhouse gas emissions in order for us to meet our goals. And this program would help navigate the complex processes that are necessary that Mr. Stoddard mentioned that they'd be able to help the schools navigate. So again, the GO is supportive of the overall concept and objectives of this legislation, and we'd be happy to work with the sponsor and stakeholders and Efficiency Maine Trust as needed to advance the program. Thank you for your consideration. I welcome any questions.
Thank you. Are there any questions from the committee for Ms. Winnie? Yes, Representative Foster.
Thank you, Mr. Chair, and thank you, Ms. Winnie, for your testimony being here today. This bill, which looks to get our schools to zero carbon emissions, is fairly stringent. And you may have heard earlier, I mentioned a school project that we had locally here, where that we installed the wood chip boiler at a cost of $1 million on a $30 million project to the state of Maine through the DOE. We also, as a backup, installed a oil-fired fire tube boiler, modern piece of equipment, fairly efficient, and used only when necessary. For instance, in times of the year when the wood chip boiler wasn't feasible to run it 24/7. My question is, in that regard, has the Governor's Energy Office looked at what it's going to take to get not only that new boiler to be zero carbon emitting source of heat, but also the many school buildings we have across the state, which have older boilers that they rely on entirely for their heat. What that magnitude of that is going to mean, especially in light of this bill. Thank you.
Thank you, Representative Foster, for the question. So just to make sure I understand, are you asking for specifics on energy usage by schools currently and what, like, the equivalent of emissions and energy use of those schools to better understand what it would take to reduce the overall emissions of schools in the state?
Yes, obviously, if we're going to plan on, and I'll just address this particular bill, but if we're going to plan on getting to zero carbon, Efficiency Maine Trust can only do so much to meet that end. When we look at the number of school buildings that there are, and again, the one that I was talking about, that was one building, a fairly large one, but not large by comparison to some of our schools in Maine. But we have many buildings that have oil boilers. And I'm wondering, the question is, has the Governor's Energy Office looked at the magnitude of what that means to get those oil-fired heating sources replaced or changed over to non-carbon emitting instruments? And also, has any discussion been had with the DOE on, who probably has more, better information on what the number of facilities are and what their heating systems are? But I'm just wondering, has that occurred? Have we looked at that? Because again, this bill is going to be fairly stringent in its requirements going forward in that regard. So, thank you.
Thank you for the clarification. So the Lead by Example report that I mentioned starts to look at these questions in state buildings. So I don't believe that all publicly funded buildings are included in that. It's a directive to start looking at what it will take for state government to meet some of these climate and clean energy goals that have been established for the state overall. So I think that's a starting point in terms of looking at some of these public buildings and what it will take to move away from high carbon fuel sources and reduce emissions. I also, in terms of this program specifically, I think it's a piece of a larger puzzle. I think it's a helpful tool for schools to have to understand what their options are and what next steps can be to begin to reduce emissions. And for that reason, I think that it's worth supporting and beneficial for the overall efforts. And to your specific question about schools in particular, I'm not aware of any specific analysis of school heating systems and kind of the energy use specific to school buildings, but that's something I can take a look at and make sure there isn't data that I'm missing on that. And if there is there is some more information, I can bring it back to the work session.
Thank you.
Great. Any follow-up questions for Ms. Winnie? Seeing none, thank you very much. We had James Rue listed as testifying, but he's not in the waiting room. So I'm assuming he submitted written testimony, which I'd direct your attention to. He was testifying in favor. And now we go to neither for nor against. And Dana Doran from the Maine Loggers.
Well, good afternoon, Senator Lawrence, Representative Berry. I assume you can hear me?
Yes.
Thumbs up. Okay, great. Thank you. I'm Dana Duran, Executive Director of the Professional Logging Contractors of Maine, trade association that represents logging and trucking contractors in the state. I'm here to testify neither for nor against. Our organization chose not to take a policy position on decarbonization for various reasons, but we did want to testify neither for nor against, and I have shared our comments as well as my testimony with Senator Maxman, so she's aware of them, and she said she's definitely willing to work with us on some of the changes that I'm going to recommend. So I'm not going to read my testimony verbatim, but I am going to bring up the 3 issues that we brought forward to Senator Maxman just to bring them to your attention. So first, obviously solar is listed as a energy source that's spelled out in the bill. I think it would make sense to be consistent for renewable energy. Obviously, the point of the bill is decarbonization, but all forms of renewable energy as defined in Maine statute are in the Renewable Portfolio Standard statute have to do with decarbonization. So I would make the suggestion that it's not just solar that's listed. I would list all of the renewable forms of energy that are already in statute, just to make it consistent. Secondly, in 2019, Governor Mills signed LD 375, which was before the Education Committee into law. And that bill and the statute states that schools should give deference to wood heating systems when considering new construction or renovation projects. It appears that the bill obviously specifies solar power purchases in section 1, which would really put the bill at odds with current law. So from our perspective, again, consistent with my first suggestion, we don't feel that it should just single out one energy source over another. And then lastly, just bringing this to the attention of the committee, in section 3 of the bill, now this is an existing statute, so this isn't something the bill is recommending, but it actually states that, quote, and natural gas conservation projects, end quote, would remain in the statute as it pertains to this program going forward. Since natural gas is not technically a carbon neutral fuel, I just wanted to bring that to the attention of the committee that might be something you want to amend further, because it doesn't seem to make sense that you want to continue to have that in statute if this is truly trying to decarbonize things. So those are the 3 issues that I brought up to Senator Maxman. Just wanted to raise them to the committee, and I would be happy to answer any questions that you have.
Any questions for Mr. Duran? Seeing none, thank you very much.
Thank you.
Jordan, are we at the end of people testifying for today?
It appears so. It appears that Jamie Rue has not gotten on yet, so I believe that's it.
Great. Super. So we're at the end of our hearings today. Thank you all for hanging out. Yes, Representative Foster.
Yes, thank you, Mr. Chair. I was wondering, I want to just get a second here to ask if we might check to see if we could get somebody for the work session from Department of Education, Scott Brown's office, somebody that might either come and talk to us about where they are with all of this and how they see it, or maybe Mr. Stoddard could talk with them and bring back some information on how that the 2 efforts might possibly work together if this bill is passed. Thank you.
Great. I think that's a good idea. Dan, is this one of your bills? Or Deirdre?
These were all mine today.
Okay. So would you be able to do that? Reach out to DOE and see if there's somebody who might be willing to comment. And if not, ask Mr. Stoddard to comment on that.
Sure, yeah.
Okay. Anything else?
Can I ask Steve a quick question about not the other bill?
Sure. Steve, go ahead.
This will take 2 seconds, and it's not the sulfur fuel. Steve, I'd like to talk to you about that if I could, about Paramount's bill. It's about blowing the tanks.
Sure, give me a call.
Yeah, thanks.
Any other things for the committee to discuss? Great. Well, thank you all for hanging out in a long hearing day, and we'll see you on Thursday, where we're going to begin discussing net energy billing.